today's little shared moment of humanity. Here is our attorney, Sandra Francis, on our first case. That is some old rock and roll poetry. Good morning.
Good morning.
Welcome to Sandra. Good morning. What's your name, sir?
Charlie. I'm just saying hi.
Oh, good morning. You're next door?
No.
Oh, you just came in to say hello?
Yep.
All right, it's public courtroom. Good morning to you, sir. Ms. Cole, can you join us, please?
Yes, sir.
All right. This is our first matter of the week. We do start early around here. It's file number 251530. It's entitled Cavalry SPV LLC as an assignee of Citibank. That's a lot. Versus Tracy A. Cole. There's a claim for $782.73. Attorney Sandra Francis is here on behalf of Cavalry. Ms. Francis, you ever been here in this court before?
Good morning, Your Honor. I believe by Zoom.
Okay. Well, maybe one day you'll win a free trip to Centerville. It's not on the way to anywhere else. This isn't a terribly large claim, but Ms. Cole indicates that she had been working with Freedom Debt Relief and sent that information to your office, or at least to Weber and Olcese's office. Is that correct, Ms. Cole?
Yes, Your Honor.
Ms. Francis, what can you tell us about it?
Your Honor, I'm looking through the file. It looks like we've been trying to make contact with them, but I don't see that that we've had any actual discussions with the debt settlement company. So I don't know if the defendant is able to reach out to her specific representative and have them contact our office. I see the last, let me see here. Yeah, I'm not seeing that we've had any actual contact. I've seen some attempted emails and attempted phone calls. But if she could have them reach out to us.
Right. Attempted emails from them to you or from you to them?
I see one email from their office on January 24th. It looks like they're just providing an updated address that they've relocated, and they just provided an updated address. But if she can, I'm assuming she's working with a specific representative. So if that specific representative would be able to reach out to us, that would be the best option. So we could, try to resolve this.
Ms. Cole, what can you tell us about that?
So I sent over the original paperwork that I had received to them. I will continue to follow up with them and ask them to please prioritize this debt to be resolved.
All right. Well, it's not very big in terms of how these things go. All total is altogether probably under $900. But how about if we continue this for 60 days for Freedom Debt Relief to contact the plaintiff?
Okay.
Ms. Francis, are you with Weber and Olcese? Or are you here as limited counsel?
No, from Weber and Olce's office, Judge.
All right, very good. All right, 60 days from now, maybe it'll be warm by then, would be May 11. at 8:30. Perhaps the matter can be resolved. It sounds like they made some contact in January. It's now March, but no substantive contact has been made either way. So let's see what we can accomplish. Your representation is accurate. Let's see if they can give it some priority and work on it. So we'll continue this. Ms. Cole, you did a good job of logging in on time. I can see you, hear you, got your name. So let's try this again on May 11th, unless the matter is resolved. Otherwise, I'll see a representative from Weber and Olsees, and you, Ms. Cole, will take another look at this in a little more than 60 days, May 11th at 8:30.
Thank you,
You're all
Judge.
free to go.
Thank you, Your Honor.
Thank you. Next, we're going to address D. Perez Harvesting LLC versus AK Motorsports and Andrew Morris. Mr. Luke Knopfinger is here for D. Perez Harvesting. Andrew Morris is present. Good morning, Mr. Morris. This matter got confused. I'm not even exactly sure myself what happened. I think the court may have caused some of the confusion, but this is a discovery hearing. Mr. Knopfinger got a judgment against this company in an attempt to collect on this judgment. He's been working on it for several years. So the matter was set for a discovery hearing this morning at 9 o'clock. Mr. Morris, would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Mr. Knopfinger indicated Friday he had spoken to you by telephone. You agreed to be here this morning at 9 o'clock, so there's no need for a show cause or anything, and bring the documents that he needed to use a discovery. So what I would normally do is then send you guys out to the conference room. You're under oath and discuss this, and I'm here if you need me.
Yeah.
But I appreciate your being here. I'm sorry about the confusion. Hopefully you guys can get closer to the finish line on this. And I'm here if you need me.
Okay, thank you.
All right, Mr. Featherstone, would you come have a seat right over here? All right, this is an unscheduled matter. People versus Ryan Featherstone, file number 251076. Mr. Featherstone failed to appear for his final pretrial last Thursday, March 5th. I think he had been in communication with his lawyer. Mr. Featherstone has $2,360 worth of unpaid fines and costs. So I set his bond at $2,360 with a 48-hour hold. Lo and behold, he showed up here at the courthouse this morning at 8 o'clock to address this. Mr. Featherstone, are you still at well, last I had was a post office box. Do you have a mail address?
No.
All right, this
I mean,
is
I
the,
do, but I don't, like, just where all my mail goes, I don't live there.
all right. So does your lawyer have a way to get a hold of you?
Yeah, she got my phone number now.
All right.
We talked Thursday.
Well, this is the case where you believe it was already taken care of.
Yeah,
And I researched it, the prosecutor researched it, and your lawyer researched it.
I
And
told you before you locked me up for 6 months that there was another case that's gonna be same thing on the same aspect, because it's all the time, same timeline. You said you could put it all together and run it concurrent. That's why I don't know if you remember that. I do.
well, we and I have discussed it. I looked it up and I couldn't find that. So the prosecutor,
And I can't even believe he's trying to charge me for Judge Oda. I even went over there with the cops and tried to get my bike back from him and he wouldn't even give
all
it
right,
back.
well,
to
don't
me.
say any more about it.
All right,
But this is a huge pain in the neck.
You ain't lying. That's why I was
You're
hoping.
supposed to show up at a certain time and date. We got a lawyer for you on a dumb trespass case. She drove all the way over here for your hearing. You didn't show up.
It was really bad Thursday, I know, because of all the storms and crap. It was bad. Like me trying to find a ride was even the worst part. I got one today, and I got one that's.
Do you need a bus
Hopefully.
pass?
Well, yeah, it kind of helps a little bit. The church gave me one, but they ain't gonna give me that. It's give me here, but won't give me back. You know what I mean? Like, why would you give me?
Well, I'll give you some.
I appreciate it.
I'm gonna reset this for March 26th. Hopefully Ms. Harden is available then.
I was kind of hoping this thing would get resolved, so
Well, the prosecutor can dismiss it. I can't.
it's hard to get rides back and forth to Centerville. Like I've been trying to get here to get my go to reset, and I can't get up and get enough ride to go here, and I miss the bus every morning because I don't
I'm
get up
gonna
until
give
late.
you 2 bus passes.
I appreciate it.
Get you here and back. Thank you to our generous donors. All right, there's one ride. They're $8 a piece. Here's another ride. There's a ride here and back.
Thank you.
You need a ride back today?
No, I know I got a ride today.
All right.
Thank God. I was almost gonna ride my bike Thursday, but I'm really glad I didn't. The storm was too bad.
Well, the storm was Friday. There was no storm Thursday.
Oh, well, Thursday. No, it rained Thursday. The day I came to court, I got soaked coming back.
Oh,
to
yeah,
my
I
spot.
guess it did rain.
Oh, yeah.
It rained real hard Thursday.
Yeah, I got soaked.
All right, so you go out to the counter and get a notice and give your best address.
All right. To the over there, room 107. All right.
All right, we'll try to figure this out. I know what you believe happened, but we haven't been able to verify it by looking at the record or otherwise. I think I have enough bus passes to last certainly for the rest of this year. Maybe longer. What's your name, sir? Just first name.
Charles Belair.
Where are you from?
Originally from, Three Rivers.
Yeah, the Belairs have been around here for a long. The Belairs were Sturgis, though.
You know my mom, Mildred,
Oh, yes.
and then my so-called sister, Andrea.
Yes.
Well, I just down in Michigan about 4 years ago.
Well, thanks for visiting.
You're welcome. You're retiring at the end of the year.
I am. The state of Michigan says that lawyers can be judges, but they can't be a judge can't run for judge after your 70th birthday.
Oh, wow.
So it's time to give somebody else a turn. Our next matter is entitled Citibank versus Bobby Hahn, also known as Bobby Joe Hobson. I have seen before me a consent judgment where the defendant agrees to a debt of $3,102.12 plus $181.90 in costs. Defendant has paid $792. So the total consent judgment is $2,492.02. I will sign it. So our 9 o'clock matter was adjourned. Our 9:15 matter is settled. We have parties doing a discovery hearing right now. Next matter isn't set for 17 minutes. And that's a little complicated, so we'll see where we are here. But I'm going to stay on the live feed because they may come back from the discovery hearing, need something. So as soon as I leave, that's when people come back.
I came in to help Mom clean up her yard from the tornado.
What part of town does she live in?
Three Rivers.
What street?
Down there by Falls, right there on East Mich.
Oh, did she get it bad there?
Mainly the trees, but thank God the structure is still standing.
Yeah, a lot of people in town with lots of damage.
Oh, yeah.
I haven't been there. You know, they don't want people driving there looking around.
Yo,
Good morning. Are you Courtney Fisher?
Yes, Your Honor.
Thank you for being here. You're a little bit early, but you are in the right place. I'm
Okay.
going to put you in the waiting room. Don't go away. Is Paul Fisher going to come as well?
He's here. Would you like him to, Your Honor?
Oh, he's here with you also? Yes,
Yes.
I'd like him to.
Okay,
All right, I'll put you in the waiting room.
thank you.
Don't go away. Good morning.
Good morning, sir.
I already made a record on this, but now that you're here, we'll expand. The title of the case is Citibank NA versus Bobby Hahn, also known as Bobby Joe Hobson. Attorney Corey Grand Maison is here on behalf of the plaintiff. Bobby
Your Honor.
Hobson is not here. You provided a consent judgment signed by
I'm actually the defendant here, Your Honor.
oh, yes, you're
Stanger.
representing the defense.
That's right. Stanger and Stanger is
The
the
plaintiff,
attorneys.
and you're here from the Huron Law Group.
Right. And I just wanted to make
Yeah.
sure that the consent judgment was entered with the signature of both sides today.
It is, I just did it. And so the matter is settled. Looked like she'd made several payments. And I'll note that you were present. Where are you from? Are you in Philadelphia?
Well, our main PO box is in Philadelphia. I'm a Michigan-based attorney.
Very good. Where are you?
The thumb of Michigan, Bay City, right around here.
I see that you're a Wayne State University graduate.
That's correct.
1981 was my graduation year.
Yeah, only 23-ish years for me so far, Your Honor.
Well, that's a pretty good run. All right. That I've entered the judgment. I'm friends with the Bay County judges who used to be prosecutors, Tim Kelly and Joe Sheeran.
Oh, yeah.
And been there a few times. All right, we're resolved. I've signed the consent order. Thank you. She's going to continue to make payments.
Yes, that's the plan.
All right, thank you for checking in.
Not a problem, Your Honor. Thank you very much.
Have a good rest of your morning. Thanks.
You too.
All right, I got two people in the waiting room. Just Courtney Fisher and Paul Fisher. This next one's a little more complicated. So we have this one, a 9:30, and then we have a 10. And then we start our criminal sentences at 10:30.
So how's the family doing?
They're all good. We didn't have any storm damage.
That's,
But, plenty of people are struggling.
oh yeah, definitely.
So we haven't actually got up to speed yet on who needs what. The United Way is all over it.
Nope.
Kelly Hostetter, of course, she's the Hostellers down there on the front lines on Friday evening. The Rotary Club may end up doing something also, but I suspect it sounds like chainsaws over there this morning.
Oh yeah, over in Union.
Yeah.
Yeah.
Well, I don't know about Union City. That's where several people were killed as a result of it. But I think the tornado grew in size after it went through Three Rivers.
Yeah, they said like it was like an EF2 in Three Rivers and like an EF3 in Union.
Okay, that sounds about right.
Well, you have yourself a good day, Your Honor.
All right, thanks for stopping to say hello.
You're welcome.
Get your chainsaw out.
Oh, it's already been out.
All right, thanks. Good morning.
Good morning.
Good morning, Mr. Goodman.
Good morning, Judge. How are you?
Good. This is file number 251837GC. It's entitled what used to be known as Oak Lawn Hospital, now under the Ella M. Brown Charitable Trust. It's pled strangely. Two separate complaints against two separate defendants are under the same file number. In the matter of Courtney Fisher, who is present by Zoom, the claim is for $12,921.79. This is a debt, a medical debt from 2022 that resurrected itself when it got filed in late 2025, 3 years later. Under the same file number, the plaintiff has sued Paul J. Fisher, who was also present, for $9,573.41. The first claim is for Courtney Fisher and their daughter, a minor child. The second claim against Paul Fisher apparently is for a minor child. So I don't know if the $9,573 is joint and several with the $12,000, or it's two separate complaints that total $22,000 or so. The defendants, again, this is 3 years after the fact, have responded each separately with a letter explaining the circumstances. And this was very stressful. Their daughter ultimately was diagnosed with epilepsy, but there's nothing attached to it. Now, the plaintiffs may have sent something to the defendants, but all I got is a pleading that says, hey, you owe us $12,323.79 without any supporting material or anything else in the pleadings. And as often happens, when it happens 3 years later, the plaintiffs make the claim and the defendant's like, well, I thought that was taken care of with our insurance. So this has got a lot of issues and sub-issues. So Mr. Goodman, the way it's pled is that Mr. Paul Fisher's segment joint and several with Courtney Fisher's, or are they two separate claims in the same complaint?
So, Judge, the Courtney Fisher is liable for the full $12,321 because the February 16th, 2024 date was services rendered to her directly, and then the November 10th, 2022 date was rendered to her minor child. Mr. Fisher would only be responsible for the debt associated with the minor child. So they are husband and wife. They have a child together. Courtney would be liable for 100% of the $12,321. Mr. Fisher would only be liable for the debt associated with his daughter.
All right. That's what I was assuming, but I couldn't tell. Now, these aren't, maybe they are to the defendant. They aren't split out. How much is, I guess, figure it out by subtracting his claim from her claim. But how much of the claim is for 2024 for Courtney Fisher, and how much of the claim is for 2022 for the Fisher's daughter? Mr. and Mrs. Fisher, do you have any knowledge about that, how this claim is broken down, or what you owe for what? Did they send you something more than the bare bone pleadings I got?
Yes, Your Honor. I called the hospital and tried to sort it out after I got the summons because I was kind of blindsided with it. Again, like you said, I thought it was taken care of with insurance. And so my portion for my services rendered in 2024 is $2,748.38.
That's correct.
And then the rest
Right,
is.
and you
for my
discovered
daughter.
that by calling the hospital?
Yes, I had to call, and when I took the total, they told me that that was my portion and the date and the services rendered. And then they told me that the other portion, November 10th, 2022, was $9,573.41. That equaled the total amount that you have.
All right. And what's your daughter's name?
Khaleesi.
All right. Now, essentially, you both acknowledge the debt, but you both mention in your letter that you were going back with the insurance company. This is a lot of unpaid debt if there was insurance in effect. Have you managed to discern anything about whether this should have been covered by insurance 3 years after the fact?
Well, we no longer have the insurance, so it was a little tricky, but I did some digging and we got an explanation of benefits, and I sent a copy. I gave a copy to you also, sir.
Yes.
And there are double charges and things. And I actually printed off, I had to get my daughter's medical records, 185 pages just to see the notes and everything. And they admit that they didn't do anything extra on the second date. There's some with the same total with the date that she was actually discharged, not the admission date. And in her medical records, it states she's doing better. She's, they actually disconnected the IV and things like that. And then we got discharged. So I don't understand why there's double charges for the same services, even though they didn't do the same services on her discharge date. And then I also printed off more, and it says admission notes, authorization verified and everything. When I go in and I look, there's several pages in regarding November 10th and November 11th stating that different authorization is verified. The emergency documentation when she was first in says the result status authorization verified. There's several different people who authorized that she needed these services. And then when they admitted her, there was somebody else stating that authorization was also verified.
Were you able to determine whether this was ever sent to your insurance company?
It was sent to the insurance company, but there was also a portion for some reason that wasn't paid. But when at the bottom of our explanation of benefits, it says family medical deductible has been satisfied. So it should have been completely covered by the insurance. I think I also highlighted that for you too, sir.
Yes. So, as I said, there are a lot of issues here. Mr. Goodman, what's your take on this?
So, Judge, as far as the complaint is concerned, for HIPAA reasons, we don't attach copies of billing records and billing statements to the complaint. We're originally provided with a summary sheet that has those exact 2 dates of service and the amounts that Ms. Fisher has
So
indicated.
they did get that?
Well, and I also, so that with respect to the complaint, that's why it wasn't attached to that. However, I've been in communication with Mr. and Mrs. Fisher, both of them, both after Ms. Fisher was served and then after we added Paul Fisher to the complaint as well. And so I have talked to them. I did receive the billing statements, which are sent to me after the fact if there is an issue regarding billing. I did receive those late last week, left message for Mr. Fisher, didn't hear back, which no big deal. We had a pretrial coming up this morning anyways. So I do have them since then. I reviewed them in preparation for today's pretrial. I can tell you that for the first date of service, which was 11/10/11/11, when she went in on an emergency basis and stayed overnight. The total charges were $23,140 for that day. There was a payment made by their insurance company of $9,575.53. There was an adjustment, an insurance adjustment, another credit to them of $4,015.26, leaving a balance for that date of service of $9,573.41. So insurance was billed, insurance paid, insurance adjusted per their contractual agreement with the hospital, leaving a balance of $95.73.41 for that first date. With respect to the second date of service, the smaller one, that one, the total charges were $4,528 and some change. Insurance paid $1,011.11. There was also a insurance allowance or adjustment of $770.01, leaving a balance for them of $2,748.38. So insurance was paid, insurance was billed, was paid, and they received some contractual allowances. And Judge.
All right, well, let me stop you for a minute.
Sure.
That's very helpful. It wasn't pled that way, and you're right, there are some HIPAA violations, but it would have been. Did you provide them with that information?
So I obtained it late last week. I did call Mr. Fisher. I don't just typically send them off unless they, I talk to them and it's okay to email it to them, or I can download it to an FTP site and they can grab it from there. Or some people are more comfortable just sending it, via first class mail. So if I had heard back, I would have certainly sent it to them in the manner in which they prescribed.
All right, well, that's very helpful to get a better understanding of the claims. All right, so what do we do from here? You guys had been in discussion. I'm willing to put you all in a breakout room and let you discuss the matter privately. You both indicated you're willing to make some payments. However, Ms. Fisher, you claim that it shows some double billings. And I can't tell whether those are double billed or they're two separate amounts of the same thing. But if that were double billed, that could affect the total amount. Mr. Goodman, do you have any objection to talking with the clients in a breakout room?
Not at all. I would be encouraged if you would allow that, Judge.
All right, I've got another matter to address, but I will put you guys in a breakout room and address that other matter. Ms. Fisher, when the button says join, you click that button and you guys can speak privately with Mr. Goodman. He did provide me with a bunch of information I didn't have, maybe you as well, at least for the basis of their claim. All right. Then let's return to our discovery hearing in the matter of D. Perez Harvesting LLC versus AK Motorsports LLC with Andrew Morris as the subpoena party. Mr. Knopfinger, what's our status here today?
Yeah, thank you, Judge. Mr. Morris was cooperative. He answered all my questions. He did not bring some documents that were requested. He did indicate that he did file taxes, it looks like for the last couple of years. And so what I'd asked Judge and what we agreed upon is to come back in 2 weeks where he's able to get those documents and bring them with him to that hearing, in addition to business records for his business for the last 3 years. So that's what we'd be asking for today.
Is AK Motorsports still in business?
Yes.
Okay, I'll agree to continue this 2 weeks. Which would be March 23rd. Let me look at that morning.
I have a medical appointment that morning, Judge. I was thinking maybe sometime that week, or you typically do. Would you prefer it to be Monday morning, Monday morning?
Well, theoretically, I guess I could put it anywhere, but I do it generally when we're doing civil matters.
Good morning. Are you Keith John Davis? And Mr. Davis, this is your initial appearance in cause number 26 DCCR 0096. You're charged with the first-degree felony offense of aggravated robbery from October 23rd of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I've been working on it, but it's a court appointment. So
Right.
I haven't heard anything.
So when you're in custody, we give you a court-appointed attorney automatically. But if you make bond, then I expect you to at least try to hire your own lawyer.
That's what I'm working on. I'm talking to Charles Ross.
Okay. So what I'm going to do is reset your case for about 30 days or so. That'll give you some time to try to get someone hired. If you get someone hired before that next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the people you've talked to so I know you're trying, and then we'll discuss your options. And if you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, if you step in front of the clerk, she'll give you your reset notice. Daryl Albritton. Good morning, you're Daryl Albritton.
Yes, ma'am.
And Mr. Albritton, did you get someone hired?
Right at the moment, I'm working on getting a new job. So they ain't paying me enough. You know, and I got bills and I'm paying child support.
Where are you working?
It's they ain't giving me no per diem. So I'm gonna go offshore. I'll be able to do it. I've been talking to people, so
You've been coming here for a long time, right?
well, I'm gonna have somebody this time though. I'm talking to a guy named Darryl Wood.
Who'd you talk to this last time?
Ruthie, Whitney Jones, and Todd Ashley.
Speak up, I'm sorry.
Rudy, Whitney Jones, and Todd Ashley.
Where are those
They
located?
in Beaumont.
Not a single one of those are criminal defense attorneys here in Beaumont
But they attorney, they lawyer.
that handle criminal cases.
Yeah,
What'd they tell you that they would charge you?
well, you got 35 up front,
Who?
3,500. But some of them, you know, they don't do payment plan, but I found out Darryl Ward, he do payment plans. I found out
Daryl
about-
Ward?
Yeah, I found out about him by dude like Thibodeau out there.
I don't know any of the names you're saying. I've been here for 30 years. So So what are your hours? How about how many hours a week do you get?
Sometimes we get like 40 hours a week, but
At how much an hour?
that's like 22. But I got child support and I got all that.
But you've been, I'm looking back now and I don't know how we've let this go as long as we have. You've had plenty of time to save up. Even if you save $20 a week, you could have been where you needed to be. So you got to make this a priority.
Yes, ma'am.
I need someone hired before the next court date. This is your final reset. I know you have bills and child support and things like that, but you got a good job. You've got to get some money and save it and get someone hired before that next court date. Do you understand? Step in front of the clerk. Brissa de Hoyos. Good morning. Are you Brissa de Hoyos? And Ms. de Hoyos, did you get someone hired?
No, ma'am, but I did want to get a court appointed.
Okay. Did you talk to some lawyers like I asked you to?
Yes, there's some like other things broke.
You didn't write it down or?
So it was in my notes and my other thing.
Okay. Are you working?
No, ma'am.
Why not?
I'm looking for a job right now.
Are you? Where are you looking?
I was gonna go back to fast food. I do hair though.
Okay. Well, if you were going to go back to fast food, when were you going to do that?
As soon as I get hired.
Have you been making applications?
Been to a couple of interviews.
But what?
I haven't been getting any calls back.
How old are you?
19.
Have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer? You need to fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk and she'll give you that paperwork. John Gray.
Yes, ma'am, yeah.
Good morning, sir. You're John Gray.
Yes, ma'am.
And Mr. Gray, this is, I'll say you've been here before. Did you get someone hired?
No, but I am selling my house. We're closing in 60 days. I already got a contract on it. Paperwork. That I can do self-representation.
Well, that's typically not advisable. Did you bring any paperwork to show that your house is under contract by
Not
chance?
in my phone. I've got the contract. Actually signed. It's signed. Okay, one too long ago, last week, I think.
Are you working?
Yeah, I'm self-employed.
Doing what?
Self-employed.
Doing what?
State federal labor laws. Hopefully.
Okay. That's what you're here for and in trouble for, right?
Yes, but no.
Well, okay, let's start with this. First of all, as a condition of your bond, I am ordering you not to attempt to sell or go into any business and hold yourself out to work for the Department of Labor or anything. Listen to what I'm saying. You cannot sell any poster or anything that has to do with employment, labor law, anything like that to a business while you're on my bond. Do you understand?
Okay.
You need to go get a job working for someone.
Okay.
Okay. And so that you can afford an attorney. If you can get one when you sell your house, great. But I'm resetting your case 30 days. When you come back, I want you to either have a job or show me where you have attempted to get a job and filled out applications or whatever it is. And again, if you are caught continuing to sell or attempt to sell any type of poster or paraphernalia or anything at all, there's no loopholes in what I'm telling you. You cannot do what you've been doing. Do you understand? If you do, your bond will be raised for violating that court order and you'll be back in jail. Do you understand? All right, step in front of the clerk for your reset.
We close 60 days on the.
You're getting a 30-day reset. I want you to do what I asked you to do between now and then.
I'm right there.
Broderick Guillory. Good morning. You're Broderick Guillory. Mr. Guillory, did you get someone hired?
Oh, no, I just recently lost my job. I just got a blessing.
Where are you working
I
now?
was in Exxon.
Okay. Where were you working?
I was working at the Golden Pass, Sabine Pass.
Okay. So, but when do you start with this new job?
I started it Thursday of last week.
You already did?
This one.
Okay. So did you talk to some lawyers? Do you know who you're going to try to hire?
I've been talking to some, but I left the paper that I had at home. I don't know.
Why would you have left it at home when that was one of the only things I asked? Everybody's, it's not hard what I'm asking y'all to do, right? Talk to some lawyers, bring me the names of the lawyers. If you don't do that, then you run the risk of me putting you in jail. I would think if I had the risk of going to jail just for not talking to a lawyer or bringing the names of the lawyer, I'd make sure I did it and I brought those names. Do you remember at all who you talked to?
After I started doing the process of getting this job, I was trying to get the money for lawyers.
But you don't know which lawyer you have or how much they charge if you haven't talked to any, right? Okay, so I'm going to reset your case one more time. You need to get a lawyer hired or you need to talk to 3 and bring me those names. And that doesn't mean just calling their office. It means actually talking to someone, getting a quote to find out who can represent you. Do you understand?
All
All right, step in front of the clerk. Tiffany Elair. Good morning. Are you Tiffany Elair? Miss Elair, did you get someone hired?
I'm gonna give it a check on Thursday. Then I was waiting. I'm waiting on them to clear it because it was so much. Then yeah, I'll be fine.
Okay, so if I reset you 1 week, you'll be able to get that taken care of.
Yes.
Okay, I'll reset you 1 week. Now, if you get him hired this week, make sure you bring the reset notice to you because if you've hired him, it has the ability to send something in and talk to us and maybe the next court date goes away for a different one.
Okay.
But plan on coming unless he tells you otherwise. Okay, step up. Is it Kyle Walker? Yeah, Kyle Walker. Okay, good. Thank you, ma'am. Darian Broussard. Good morning, you're Darian Broussard. And Mr. Broussard, were you able to get someone hired?
No, I was trying to, but he didn't set my money because he don't take down payments. I talked to 5 other lawyers.
Who'd you talk to?
I talked to Judge Walker. He take 3,000 down, but I'll try to break 1,000. And I talked with Mr. Ross. He takes like 2,000 cash. I talked to what's his name? Kelly, Mr. Kelly, law firm. They want 5,000 cash.
Okay.
So I'm trying to go with like Mr. Ross.
Okay. Do you think you'll be able to save up and get that taken care of if I give you? All right. Thank you for doing what I asked you to do. I'll give you one more reset. You can try to get Mr. Rojas hired. If that doesn't work, make sure you talk to some others and then we'll see what we can do next time. Javon Johnson.
He called.
He's in custody, Judge. We took her into custody on a misdemeanor warrant.
Oh, okay. Thank you. The misdemeanor warrant. I don't know. Maybe I'll just leave this one. Okay. Ronnie Lanza. Good morning. Are you Ronnie Lanza?
Yes, Your Honor.
And Mr. Lanza, were you able to get someone hired?
No, I was not. I was gonna just put a court appointment.
Did you talk to some lawyers?
The only person that I tried to go ahead and contact was Charlie Rojas. I don't exactly live near here. We're 4 hours away. And I definitely know that I cannot afford a lawyer.
Are you working?
I am working.
Where do you work?
Soda Pines Nursing Home and Rehabilitation Center.
Say it again, the first part.
Soda Pines Nursing Home.
Soda.
I'm a CNA.
Okay. And what are your hours?
I work an average of about like 48 hours a week.
Okay. Why did you only talk to one lawyer when I asked you to talk to 3 or ordered you to talk to 3?
Well, I wanted to go ahead and see how much I'm making. I have my pay stub. I get $500 taken out of each check for child support. I only make $15 an hour.
Okay.
And I have court fees from a thing I'm on probation for already.
Where are you on probation?
I'm being supervised by Bastrop County, but it's originally in Medina.
Okay. For what offense?
Aggravated assault.
Is there a motion pending or anything based on this case?
No, I have everything here.
Okay. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're gonna swear under oath that it's all true and correct, and then I'll take a look at it.
Yes, sir.
Step in front of the clerk. Corbin Rayleigh. Good morning. Are you Corbin Rayleigh?
Yes, ma'am.
And Mr. Rayleigh, were you able to get a lawyer hired?
No,
Who'd y'all talk to?
the same as last time, Crenshaw, Bearden. I don't remember the name off the top of my head, but I got the folders in the car. I just forgot it this morning.
Why would you have left it in the car?
It's Monday. I'm so sorry.
It's Monday.
Yes, ma'am. I'm sorry. I didn't mean to. It just tired this morning and stuff. I came in here.
So that's not, you understand how silly that excuse sounds,
Yeah.
right? We're all tired. It's Monday.
It's not really an excuse.
Okay.
Sorry.
Are you working?
Sometimes it's just like maybe one or 2 days a week for my dad. He does contract business.
How old are you?
20.
So why aren't you doing something where you're working full time?
I'm waiting for this to be over, honestly, so I can.
Well, you can't wait for this to be over because you got to have money so you can hire a lawyer,
Yes, ma'am.
right? So that's what we've gone through before.
Yes, ma'am.
So you've got to follow the instructions that I've given you. You've got to talk to lawyers. You've got to actually try to hire them, and you actually need to go get a job. I mean, it's great that you can work a day or two for your dad, but if it's not full time, then you need to get a full-time job.
Yes, ma'am.
There's plenty of people out there that are accepting applications and hiring. I'm going to reset your pace for 30 days. You need to get a job within 30 days.
Yes, ma'am.
If you get one, bring a pay stub or something that proves that you got that job. If you don't get one, then you need to bring me every job, a list of every single one you've applied to. Do you understand?
Yes, ma'am.
You also need to talk to 3 lawyers so that when you do get a job and make some money, you'll know who you want to hire. Does that make sense? If you don't do all of that and bring that stuff to me, then your bond's going to be raised and you will go to jail.
Yes, ma'am.
Step in front of the clerk. I have to start putting some in so that we understand I'm serious. I guess. Aaron Roberts. Oh, did you just tell him about his pants? Thank you. Good morning. Are you Aaron Roberts?
Yes, ma'am.
And Mr. Roberts, were you able to get someone hired?
No, ma'am. I did talk to 4 lawyers like you asked. I went to the interview like you asked. Wait on them to call me back. If they call me back with a felony. And I went to the DMV to get an ID to get a job.
Good. All right. What lawyers you talk to?
I go in the paper today.
Thank you.
Duham Jones, like I told you, and William Marcus Law Firm, Walker Law Firm, and I talked to a man named James Patrick.
Okay.
So
So thank you for doing everything that I've asked you to do. I'm gonna have you fill out some paperwork this morning to see if you qualify for court appointed lawyer. Make sure you fill it out accurately and completely because you're gonna swear under oath that it's all true and correct with the page. Step in front of the clerk. Michael Sarant,
I didn't notice.
I'm sorry.
I didn't notice the correct one. Like, it may not be shown.
Yeah, that's okay. Yeah.
I mean.
Is he-
He follows, it's.
You hired Mr. Kimbler.
Yes, ma'am.
Okay, we're just checking on that. Okay, but you sent it yesterday? you said?
Well, I sent it to me, she should have filed it.
I'm sorry.
I sent it to my secretary and then she files it, so
Okay.
she filed it.
All right, so we'll just reset your case, stay in touch with Mr. Kimbler and your bondsman, and they'll let you know when you need to be back.
Yes.
All right, you're free to go, sir. John Tat Taylor. Good morning, you're John Tat Taylor.
Yes, ma'am.
And Mr. Taylor, were you able to get someone hired?
No, I haven't, but I done talked to a few of them. I'm gonna try to hire one today. We're running town. Just I called some of the local lawyers and I said, Miss West, and they're like, oh, you're just trying to get the rule because you know they say about they know that you asked to talk to 3 lawyers, but I got a retainer fee with me and I'm hurt because you know I'm from Turner County. I'm gonna make sure I get one hired today.
Who are you hiring today?
Dr. James. I don't even know because it's the same person my co-defendant got. And I think I'm gonna try to talk to him. So I'm gonna find somebody.
Now, sometimes they can and sometimes they can't represent co-defendants. So you have to make sure that that attorney knows. But how are you going to hire him today if you don't even know his last name?
He my co-defendant. I'm gonna call him and get his information.
Okay.
I was doing that before I came in here. And I talked to him one time. He was like, oh, you just trying to talk to 3 lawyers because Miss West asked.
So here's the thing, when you call lawyers, it's to try to hire them. It's not just for that. So when you call, you don't need to say, Judge West told me to call. You need to say, I need to hire a lawyer. The point is to hire someone, not just to go through some fake process where.
When we started talking and I said something like that, you know, he automatically thought that's what I was just doing.
Okay, so then why are you going to hire him if he didn't want to talk to you?
I will talk to him in person now, because that was over the phone. No, my co-defendant said it was pretty good where he moving, but if he can't.
So here's the thing. I understand you're coming in from out of town, but for me, that doesn't matter. All right. You need to get someone hired before the next court date. Whoever it is, doesn't matter. If you've got the money to hire someone, then you need to get someone hired before the next court date. There's no excuses that I had to drive in or I couldn't do it. Get it taken care of one way or the other. Okay.
I will.
Step in front of the clerk.
Jennifer Ruth. Miss Ruth is before the court with her counsel, Miss Gundy. We're here on a final ILC violation hearing. Miss Gundy, does your client wish to have a hearing?
No, Your Honor.
All right, Miss Ruth, you understand you are entitled to have a hearing?
Yes, Your Honor.
You wish to waive that hearing and admit to the violation?
Yes, Your Honor. Yes, Your Honor.
All right, Ms. Ruth, at this time, based upon this violation, it doesn't make sense. This case is so old. I know that you've paid off your arrearages, but because of the nature of the violation, the court cannot allow you to complete the ILC. So based upon your plea of December 3rd of 2018, the court is now going to find you guilty. Is there anything you want to say to me before I sentence you?
I am the sole care provider of my mother. She has a lot of medical issues and I'm just ready to move on and get my license.
Okay.
Get a place for us. My sons are no longer living with us and this is the reason why I'm coming and getting this all taken care of.
Okay. All right, at this time, then, the court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court is going to order you to serve 17 days in the Warren County Jail. I'm going to give you credit for the 17 days you've already served, and I'm going to terminate. At this time, that's going to terminate. There's not going to be any further supervision, okay? The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. The child support arrearages have been paid in full. So, anything else?
No, Your Honor.
Anything else?
No, Your Honor.
All right. Good luck to you, ma'am.
Thank you. Thank you.
Dontrell Robertson. Dontrell Robertson.
Dontrell Robertson.
Okay.
Where's that? The Holiest?
No response, Your Honor. Bond will be forfeited for non-appearance and reset at 100,000. Kyle Whittington. Good morning. You're Kyle
Morning.
Whittington.
Yes, ma'am.
And were you able to get someone hired, Mr. Whittington?
Not yet. You told me to bring the face up to show you what I'm actually making now, like, so you can see like the difference, like I actually get something hired, probably soon. There's a little bit more time if you don't mind. There we go.
Who are you planning on hiring when you save up the money?
I was gonna be the Gertz Kelly, I think it was.
Okay. That's to the bailiff.
I got 3 of them. It is like per week.
Thank you. All right, thank you for bringing that. I will give you one more reset. You need to try to get someone hired in him before that next court date, all right? Step in front of the clerk. Mr. Burbank?
Yeah.
You have Rakeem Allen.
Yes. I have not seen Mr. Allen.
Morning.
Yeah.
Good morning. Well, I said it was a group. Good morning. You just looked away after I turned or before I turned. Good morning, Mr. Burbank.
Good morning, Aaron.
How are you today?
Peachy.
Good.
Not right. Hold on.
Good morning, sir. You are Hakeem Allen. This is cause numbers 25 DCCR 1163, 1164, and 1697. Mr. Burbank, what is the announcement?
Your Honor, I believe that some more offenses coming. You're still in the discovery process.
Okay,
I would ask for a reset. I have talked to the prosecutor. And that was the indication.
Judge, I did speak with Mr. Burbank's office last week. They filed a letter of rep on the new case that was recently indicted. So I do have all of that. And I don't mean to ask this to catch Mr. Burbank off guard or anything, but based on Mr. Allen's prior criminal history and these offenses, would the court just take a quick look at the bonds, maybe?
I don't even have the new case. If it was indicted last week, it's not on our docket. What's the cause number of that? And what's the charge?
It's a possession. It's 25 DCCR 1697.
Oh, I have that one.
Yes, the new indictment didn't come last week, but it was just caught up with these other cases.
Okay, because that actually, well, so the offense date from the possession is actually 2024. And then it was after that that we had the other possession and the evading. Are you wearing a drug patch?
Yes.
Oh. Let's see. I don't see that we've had any. It's like you tested positive back in court. What was it, last October? You've been wearing a drug patch ever since? Have you gotten a change every 2 weeks like you're supposed to? Let's do this just to make sure, since I don't see anything, let's have you tested this morning before we do a reset and then we'll go from there. And is there any other case you expect something else? Do you expect another case other than these three?
When I initially talked, I don't know this one. I mean, I'm not trying to act, but when we talked, I thought there were a couple more out there, but maybe not.
And I'll look into that.
Let me hold it while he gets a drug test. Can you look in to see if there's something else and y'all talk because I want to know what's going on. Have a seat in the jury box.
And it may be that I had one regular in the state jail and I got the newest regular. Charlie was initially.
Okay, yeah, double check if there's something else.
I will check.
Please, ma'am. Jermaine Young, Mr. Burbank. Jermaine Young.
You should be outside.
Good morning.
Jermaine Young. She needs to pull a bit to extra burdens.
Good morning, you're Jermaine Young.
Yes, ma'am.
And this is 24 DCCR 0916. I have a note that we've been waiting on some DNA results. Do we know where we are
I
on
can
that?
speak to that, Your Honor. I was out of town Thursday and Friday, but before I left, I prepared these cases for today and saw on the docket DNA pending. Not finding anything, taking a brief look, I contacted the detective on the case to ask him about it. I've read my email with him to Mr. Burbank this morning, and it's his belief that it was never sent off because there were never swabs taken because there was a delayed outcry.
Okay. So there's not any and none anticipated.
As I stand here now, I don't believe so, but I did tell Mr. Burbank I would continue to research that issue.
Okay, well, if we don't, that's what we've kind of been anticipating or waiting on or thought we were waiting on. And so I'm going to do one last reset. This will be the final
One last reset. I mean, we were here 3 or 4 times and it was in the lab and.
Yeah, we've talked about.
Talked about calling them and was told.
We did,
they
yeah.
called, and now all of a sudden.
Yeah, so let's just do one more reset. And if for some reason that was just not good information, then that's what it is.
And
If there's something out there that you find, obviously we'll talk about it at the next court date.
That's fine.
All right.
To do that. Thank you.
Thank you.
Thank you.
Stay in touch with
Cheers,
Mr.
sir.
Burbank and your bondsman. They'll let you know when you need to come back.
Ron, I have to go to CDC for something. I'll come back.
Okay,
I mean,
sounds good. Thank you. See, Mr. Barrington. You saw Mr. Barrington. Mr. Kimler, you have Kaylin Billups. Good morning. Are you Kaylin Billups?
Yes, ma'am.
And Ms. Phillips has a motion to revoke her probation and cause number 19-32315. And what is the announcement?
Again, Your Honor, we could proceed on the administrative violations. I would plead not true to any new offense.
So there's no agreement. You just want to go through the motion at this time?
Yes, ma'am.
Ms. Phillips, raise your right hand. You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes.
All right, put your hand in. Thank you, ma'am. And will she waive the formal reading of the motion?
She will.
Ms. Phillips, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation September 25th of 2019 for the second-degree felony offense of aggravated assault with a family relationship, and that was a 10-year deferred probation. Is that correct?
Yes.
It alleges you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated with an open container, November 24th of 2024. And is that true or not true?
Yes.
That's true. I need you to say true or not true. Thank you. Count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 3 alleges that as of November 25th, 2024, you were $2,504.03 behind in your restitution to the victims. Is that true or not true? And then count 4 alleges that you're behind in your court assessed fees as of November 25th of 2024 in the amount of $6,756. Is that true or not true?
Yes.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
All right, then I'm going to find counts 1 through 4 that you entered those pleas of true freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But I'm going to reset your case for sentencing so that the probation department can do an updated report. And we'll come back and go through sentencing on that date. Obviously, anything that is important for me to know, make sure you get that information to Mr. Kimler. He'll present it to me on your behalf when we come back. Based on those pleas, do either of you anticipate witnesses?
Or perhaps some mitigation. No, Your Honor.
Okay, we'll just set it for a regular hearing then for sentencing. All right, you're free to go. Ma'am, can you come right up here? She needs a fingerprint. Mr. Kimler, you've got Julissa Cortez Estrada.
She's brother's shot. Thank you. Pretty weird on pre-trial diversion for this case. She has a completely clean criminal history.
You haven't filed anything yet on
I haven't filed it yet. I want to discuss it first with Mr. Nicholas. See if he would be amenable to that.
Well, why don't y'all talk about that this morning and that way?
That's right.
Okay, I'll hold it. Just have a seat, ma'am. Let's see, is Mr. Peraza? Good morning, sir. On Juan Martinez? Yes, please.
And Judge, just a quick reminder, my client is a Spanish speaker. The court has allowed me the opportunity to translate for me.
Thank you. Good morning, sir. You're Juan Martinez?
Buenos días, Juan Martínez. Yes, ma'am.
And this is 25 DCCR 0401. And Mr. Martinez is charged with assault on a peace officer. And what is the announcement?
Judge, we previously worked on a deal, so I believe we're ready to plea this case today.
Okay, I'll hold it while y'all take care of the paperwork. It's all on the tablet. We've got probably some local lawyers who could help you figure that out, or Miss Werner on the end can help you as well.
Absolutely.
Thank you.
Briefly.
Yes.
On discussing with Mr. Nichols, I suggested 2 week reset. I should have an answer on pretrial diversion unless we disposed of it without a trial.
Do you think 2 weeks is enough to get that answer?
Not to get a real answer.
No, I don't think so. We'll do a normal reset.
I would suggest.
Make sure you get that to them quick because it does take a little bit. Thank you. She's free to go. Mr. Ward? Daryl Ward, Mr. Ward? Is Bart Thibodeau here? Bart Thibodeau? I'm just wondering if he's seen his attorney, if he's out there.
I'm sorry.
Oh, okay. Okay.
Yeah,
Okay, thank you. Yeah, just have him wait on his attorney. His attorney is running late, sorry. And then Mr. Barrington. What's that? I didn't see you on the docket unless I'm skipping.
30, and then it was a examination joint, and then we hired on.
Oh, you did?
Yes.
Sorry, I probably called it in maybe before. What was the name?
Brian or me.
Remy?
It's on our legal.
I don't even see it on our initials. Yeah, probably look it up and see. And Adam's in somewhere else. And then Mr. Lewis, is he working on some stuff? I just saw him walk through.
No, I need to get to it in my.
Court does call the case of the people versus Mackenzie Nyquist.
Good morning, Alexander. Good morning, Your Honor. My name is Mary Carthew. This is Matthew. We're appearing on behalf of our client, Ms. Nyquist, and student attorneys under MCR 8.120, under the supervision of attorney Sarah Allen.
And you're requesting permission to practice, I presume. I missed that part of it. Okay. Permission to practice is granted. All right. What are we doing? I have a plea sheet. Is that
I believe so, Your Honor.
correct?
Yes, Your Honor.
All right. The plea agreement indicates that the defendant will be pleading no contest to the charge of domestic violence first offense. The 93-day misdemeanor. Upon her successful plea to that charge, count 1 would be dismissed. Further indicates that there is a sentence agreement of no upfront jail. That's the court's entire understanding of the.
That's correct, Your Honor. Yes, Your Honor.
All right, very good. May I have the defendant sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth?
I do.
What's your name?
Mackenzie Nyquist.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That's a misdemeanor. Punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes. Yes.
Well, do you understand that those are the maximum penalties?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
2 things about it I have to make sure that you understand. First, it first of all means that you're not further desirous or want to contest this charge. Do you understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Sir.
All right. Basis for the no contest plea, counsel?
Your Honor, Ms. Nyquist has.
Oh, no. Somebody's going to come up and whisper.
Oh.
Yeah.
This is.
Civil liability. Your Honor.
We just came back from break, Judge.
Pardon?
They just had a week off of school.
So.
Monday morning, a week off of school.
So that doesn't, why are you doing excuses? It's okay. She didn't need an excuse, but when it was gonna turn into a full sentence, I'm like, well, anyway, all right. So ma'am, to the charge of domestic violence first offense, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
Or you signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Yes, sir.
And because, well, I won't ask that question. Court has been provided Pittsfield Township Department of Public Safety report for their case number 2519132. Any objection to the court reviewing that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14-1 probation. Sentencing in this matter will be.
March 30th, not 1 p.m. Wait. It's the same day and time as the other hearing. Or
Huh? What's the problem?
April 6th work? Yeah, that's okay. Yes, Your Honor. April 6th, please.
What's wrong with the 30th?
Yes, sorry. On that date.
Oh,
I do.
more trouble? Never mind.
Should I plead the 5th?
Probably best you do. Sentencing in this matter will be April 6th, 2026. 1 p.m. Correct. All right. Will you guys still be here? Or you guys will be on another break or something?
We'll be here, Your Honor.
Sure.
Yes.
Don't work around this school schedule. All right. Okay. Bond will continue. All right, thank you. On your way out, stop down on the left-hand side. My probation department is down there. Stop in and check with them so we can start the sentencing process.
Okay.
And Your Honor, I just wanted to add, I believe on the docket today, there was that bond violation.
Yes.
I'm intending to proceed on that today. I would just ask the court to reiterate the no contact in the meantime until sentencing.
All right. Continue the no contact. You understand that?
Yes, sir.
All right. I don't expect to see any more even indications that there's any. Understood?
Yes, sir.
All right. Thank you.
Thank you, Your Honor.
Thank you. Thanks, guys.
Court stands in. All right. No, I'm good. Thank you.
Good morning. Are you Treasurer Harris? And Ms. Harris is charged with unlawfully carrying a weapon on prohibited place and cause number 24 DCCR 1482. And Mr. Lewis, what is the announcement?
Judge, I've received the discovery, of course, in the offer from the state. I've talked to Ms. Harris about it a little bit, but I would like to speak with her and her parents a little bit more, especially given her age and, her being in school at this time.
All right. Any issues with when we'll reset?
No, Judge, just would you please admonish her, especially if she's still residing on the campus of Lamar, that she is absolutely not supposed to have a firearm anywhere on the Lamar campus.
Are you living there?
No, ma'am.
Okay, I didn't think so. So At this point, a condition of your bond based on the nature of the offense, and this may change in the future, is that you have no firearm at all in your possession, wherever you're living. You understand? So you can't have one in your car. You can't be with other people that have them. You're just not to be around firearms at all. Okay. So we'll just do a normal reset. The case is a little old. It looks like you were just appointed not that long ago. So we'll reset it and then we'll see where we get. Make sure you stay in touch with Mr. Lewis, make an appointment, go visit with him about everything. And that way we'll know what we're going to do with your case at the next court date. Okay. You're free to go. Thank you.
Judge.
And you've got Devontre Johnson, Mr. Lewis.
Yes, ma'am. This man. Yes.
Good morning. You're Devontre Johnson.
Yes, ma'am.
And see, in clause number 25, DCCR 0438, Mr. Johnson's charged with failure to comply with sex offender registration requirements. And what is the announcement?
Judge, Mr. Johnson came to the office, met with me. There is some additional information I would like to give to Ms. French. She has conveyed an offer to us last week that I, conveyed to my client. But I just get a little time to.
And it looks like you were just appointed also on this one as well. So we'll just do a normal reset. Mr. Johnson, make sure you make an appointment visit with Mr. Lewis before the next court date so that you can go over all the information that he's received, and we'll see what we're going to do with your case at the next court date.
Yes.
All right, you're free to go.
Aaron Roberts. Right here.
Crystal Julian, Mr. Lewis, it's a sentencing. Are you Crystal Julian? And based on some of the information in the pre-sentence report, I want to have Ms. Julian tested also before we go forward with sentencing. Ms. Julian, have a seat in the jury box. We're going to have a drug test done. Richard Volry, Mr. Lewis. Good morning. You are Richard Volry.
Yes, ma'am.
And Mr. Volry is charged in clause number 25, DCCR 1746 with aggravated assault with a deadly weapon. Ms. Malfino and the state has filed a motion asking that I increase that bond, which is currently set at $20,000. Ms. Malfino.
Judge, I spoke to Mr. Collier, the complainant in this case, and filed that motion to increase or modify as he chooses. Based on that conversation, he has some concerns that Mr. Volry is contacting him or driving by places where he either resides or works, so on and so forth. So I've just asked if the court is not inclined to increase the bond at this time, if you will just admonish him about what a no contact order in your complaint.
I will. Do you have any witnesses?
Judge, I had to ask him to be here this morning. He called very early. He had a medical emergency and needed to go to an appointment. They had called him in with some abnormal results and he needed to take care of that.
Mr. Let's see, is a GPS a condition of this bond at this time?
I don't think so, Judge.
So here's what I'm going to do, Mr. Volry, based on the nature of the offense and what Ms. Malfino is relaying to me. I'm not going to increase the bond today without witnesses and things like that. However, I am going to modify the condition of your bond so that there's no issue, hopefully, with where you are, where you're not supposed to be and things like that. So I'm going to order as a condition of your bond that you will wear a GPS monitoring device. You will have 24 hours to get that device. You can talk to Mr. Lewis or your bondsman. They can let you know where to get that. You've got to have that on within 24 hours. You obviously have a no contact order already with
Byron Collier.
Byron Collier. And so you're not to be anywhere near, around, or communicate with or contact Mr. Collier. That includes going anywhere near his home and or where he works. Do you know where he works?
I mean, I was going to answer that question. I just happened to go into the place where he passed by the place where he works. I did not even know he worked, and I seen the gentleman, and I kept on going.
So here's the thing. Now that you know where he works, you need to take a different path. Does that make sense? So there's always more than one way to get somewhere. So what's the place of business?
It's still furniture.
There is a convenience store, the Chris Food Mart, at 3090 Gulf Street, and he also has an antique shop. I don't know the address of that, but I can get it to Johnny's or whoever for the GPS when I'm able to speak with him again.
You know where the furniture store is?
Yes, ma'am. As a matter of fact, I passed right around the corner from my house. I just happened to pass in front of it.
Okay, so obviously you cannot go to the Chris Food Mart on 3090 Gulf Street. Do you understand? Do you know which one I'm talking about? Okay, cannot go there. And you cannot, if there's another way out of your neighborhood or to get around that antique store or furniture store, you're not to go near that as well. Okay. And then, because what can happen is if for some reason he continues to feel like you're doing those things either on purpose or to threaten or something like that, then we'll end up back in here with probably another motion. We'll have a whole hearing with witnesses, and your bond could be raised for not following these court orders and these restrictions, and you could go back to jail. Do you understand?
Yes, ma'am.
Okay, so it is extremely important that you understand how serious it is not to have any type of contact, and that means just driving by. Okay. Okay. All right. Stay in touch. What?
Do we ask for what she?
Sure.
You know, he does not work at the Chris Food Mart. I said, Chris is telling me to come back and work. And what's the guy's name? Collier, Mr. Collier? He does not work there.
He doesn't work there anymore.
And I really need a job to go back to. Mr. Chris is calling me to come back at the front mart.
Okay. Let's do this. For now, I'm gonna have it, leave it the same. Will you please make sure of that? Get that information to Mr. Lewis. It's fine with me. If he's not working there and they want to hire you, that's fine. If he's working there, then you can't. But if he's not and just doing the furniture, I don't want him to also prevent Mr. Volry from being able to work. Okay, so make sure you don't go do that until you talk to Mr. Lewis. Ms. Malfino will check on that today, get back with you, and then we'll go from there.
There's some, he was on the designation docket last week. So still looking for an attorney. He hasn't qualified.
Oh, okay. And yeah, make sure you try to get that taken care of also, which obviously that's why you need to get a job. Okay. Mr. Lewis is your court appointed attorney, but because you bonded out, I expect you again, just like I told you before, nothing's changed. You need to try to still hire a lawyer and get a job and all of those things. Bring me that information in your next court date. Okay. But stay in touch with Mr. Lewis regarding where the Chris Food Mart thing. Okay.
Please.
All right. You're free to go.
Thank you.
Thank you.
The time they did this was essentially.
Mom's next door.
Want to understand that.
Everybody's Marvin. No. Excuse me, Mr. Parker, you have Delvin Jones.
Yeah, Your Honor, I'm waiting on Mr. Coleman. We got to kind of figure out what we're gonna do. I have an offer from him, but just, I don't think what he's.
Okay.
Confusion.
I'll hold it.
Okay. Wait now. I got Mr. Smith.
Any reason not to go forward with sentencing?
No, from the.
All right, Mr. Green, and clause number 24, DCCR 1159. Again, I'm going to find that you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That is going to include having a substance abuse assessment and then following any recommended treatment if they think there's any. So whether you think there's an issue or not, if they say you need something, then you'll be required to do that. If you do everything that you're supposed to on this probation, this is an excellent opportunity because you're not a convicted felon. And at the end of the probation, if you successfully complete it, the case will actually be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be found guilty and you could go to prison for between 2 years and up to 20 years. Do you understand? And so probation also, just because it sounds like there might be some stuff going on in your life, some issues, probation's there to help you. If you need help with housing, if you need help with getting a job, whatever it is, talk to them ahead of time. Get that help ahead of time so that you don't get behind or not show up or kind of get back down the wrong path with drugs or something like that because of the stress of life and then end up back in here just for those reasons. All right. Be open and honest with your probation officer and they're there to help you. We want you to succeed. Everybody does. Okay. All right. I'm handing you the trial court certification that shows this was an agreement that I followed. So you waived your right to appeal. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir.
Thank you, Your Honor.
Thanks.
Yes, thank you very much.
Thank you.
Okay, so we are back on, again, you're Juan Martinez.
De vuelta, sos señor Martínez? Sí, señor. Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, we do, Your Honor.
Putting the lesser included, Judge.
Class A resisting.
Yes.
Mr. Martinez,
Señor Martínez.
the state has elected to proceed on the lesser offense of a Class A misdemeanor resisting arrest
Categoría A, resistir arresto.
from cause number, from March 23rd of 2025.
En marzo 23 del 2025.
And how do you plead to that charge?
Este cargo, ¿cómo te declaras? Guilty.
Are you pleading guilty freely and voluntarily?
¿Y te estás declarando culpable por tu propia voluntad? Yes, Judge.
And are you pleading guilty because you did what they've charged you with?
Estás declarando culpable porque hiciste lo que están alegando. Yes.
I have here on the tablet some documents that have your signature on them
Tengo acá en la tableta unos documentos que tiene tu firma
that the state's marked as exhibit number 1.
que el Estado ha marcado como exhibit número 1.
Before you signed these, did you go over them with your attorney?
Antes de firmar tus documentos, ¿les pasaste con tu abogado? Sí, sí, señor. Sí, señor. Yes, ma'am.
And did he fully explain to these documents to you and translate them in Spanish?
Y el abogado tuyo te lo explicó completamente y te lo pronunció en la lengua. Yes, ma'am.
And it looks like the agreement that you've reached is for 1 year deferred probation.
Y luce como que el acuerdo a que ha llegado con el Estado es un año probatorio deferida.
There would be a $300 fine,
Va a haber una multa de $300
and you would be required to follow all of the rules of probation.
y tenés que seguir todas las reglas de probatorio. Yes, ma'am.
And is that your understanding of the agreement?
Ese es tu entendimiento del acuerdo que firmamos. Yes, ma'am.
And you understand if I follow that agreement, you cannot change your mind or appeal your case.
Y entendés que si yo decido aceptar este acuerdo, no puedes cambiar de opinión o cliente y no puedes apelar este caso. Yes, ma'am.
Excuse me. And are you a citizen of the United States?
¿Sos ciudadano de Estados Unidos? No, ma'am.
I want to make sure you understand if you're not a U.S. citizen,
Entendiendo que si no sos ciudadano americano,
a plea of guilty or no contest
una declaración de
could result in your deportation,
podría resultar en contestación familiar
exclusion from admission to the country,
que no te tengas el poder de país,
or denial of naturalization under federal law.
o que te nieguen la ciudadanía americana o puede ser de federales.
Do you understand?
¿Entiendes eso? Yes, ma'am.
State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Martinez is not competent?
No, Your Honor. My opinion is that he is competent.
Mr. Martinez, I'm going to find that you entered your plea of guilty freely and voluntarily.
Puede aceptar que es una declaración de culpabilidad cuando no tengo voluntad.
Find that you're mentally competent and understand the nature and the consequence of your plea.
Estoy diciendo que estás bien mental, entender las consecuencias de todo este proceso y la consecuencia de tu declaración.
Find sufficient evidence to find you guilty.
Y encuentro suficiente evidencia para encontrarte culpable,
However, I'm going to follow the agreement that you made with the district attorney
pero voy a seguir el acuerdo que hiciste con la fiscalía
and defer all proceedings and place you on probation for 1 year.
y voy a deferir todos los procedimientos y ponerte una probatoria de un año.
You're ordered to pay the $300 fine
Tienes que te ordenan de que pagues la multa de $300
and to follow all of the rules of probation.
y que sigas todas las reglas que te imponga por. Yes, ma'am.
If you do all of that, this is a great opportunity
Si haces todo esto, es una muy buena oportunidad.
because you don't have the conviction on your record.
Tenemos que ser convictos de tu récord.
And if you successfully complete the probation,
Y si cumplís la probatoria satisfactoria,
the case will be dismissed and you'll never have the conviction on your record.
el caso va a quedar desestimado y no vas a tener la convicción de los récord. Yes, ma'am.
If you violate any condition of probation,
Si más cualquier condición de la prueba
you'll be brought back into court,
se volverá delante de mí,
found guilty of the misdemeanor
ahí
offense,
sí te voy a declarar culpable
and sent to the county jail for up to 1 year.
y te puedo mandar a la cárcel por un año.
You understand?
Yes, ma'am.
All right, I'm handing you the trial court certification
Acá te estoy dando la certificación de la corte,
that shows this was an agreement that I followed, so you waived your right to appeal.
demostrando que este es un acuerdo que yo seguí, entonces estás dando el derecho de apel.
Probation will need to talk to you today, and I'm sure your attorney will help you with that. She's sitting at that desk right over there. If y'all will just stop and talk to her on your way out.
Probatoria va a tener que hablar contigo hoy antes que nos vayamos. La señora que está sentada ahí, vamos a hablar con eso. Saliendo de acá, vamos a hablar con ella. ¿Hay alguno más? No. That's it. Thank you, Your Honor.
Thank you. Good luck.
Maybe excuse me.
Yes, thank you, sir. Thank you.
Council, Mr. Clark, Mr. Harris, on behalf of the state of Ohio. Mr. Harris.
Your Honor, we've had pretrial discussions in this matter. It's my understanding we have reached an agreement. My understanding is the defendant is going to change his plea to guilty to count 1 of the indictment. That's aggravated possession. a felony of the 5th degree. And if that is done, the state has agreed to dismiss count 2. My understanding is there will be a PSI ordered and we'll come back for sentencing at a later date.
All right, Mr. Clark, is that accurate?
That's accurate, Your Honor.
All right, Mr. Smith, they're telling me you're going to change your plea to guilty to 1 count from the indictment. Before we get to your change of plea, I am required to go over some things with you. Okay, sir? How old are you?
41.
How far did you go in school?
I don't know, like 10 or 11.
Can you read and write?
Yeah.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you in this case?
Yeah. Or no. I mean, I talked to him. I don't.
Well, you know what
I
a
don't
promise.
understand the question.
Do you know what a promise is?
Yeah.
Has anyone promised you anything?
Oh, no.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation you've received from Mr. Clark?
That's debatable.
Why?
I don't know. I don't know. I'll figure it out later.
Well, that's not the point. See, we're going to cover this today because if you're not satisfied with Mr. Clark, I'll appoint someone else to represent you.
That would be cool. I would be okay with that.
All right, Mr. Clark, you're excused.
Thank you, Your Honor.
Pick a name for Mr. Smith.
Regards here, Judge, Mr. Vogt, Keely Chambers, or Jeff Guyman. Actually, Keely's no longer on the list. So.
Oh, that's right. Mr. Guyman. All right, the court will appoint Mr. Guyman to represent you in this matter, Mr. Smith. I'll reset this for a pretrial with Mr. Guyman. That's all.
Your Honor, as far as time is concerned, is this held against the defendant from here to the next hearing?
What's your time? What's your to be tried date?
I believe we've got May 22nd.
Yeah, I'll attribute this to the defendant. Thank you.
Thank you.
Is there no bond now?
Now you have an OR bond with electronic monitor. Problem is, Mr. Smith, is that the homeway video that community corrections listened to and watched, there seemed to be active drug trafficking going on in the home in which you indicated you were going to reside. Your name's not on the lease, and you tried to submit a false or phony lease to community corrections to get out of jail. So you have an OR bond at this point in time. It's just you're not going to go back to that house where there's apparent drug activity going on. So
am I allowed to get a motel and stay in a motel? Because I do have a job that I would like to get back to work.
Well, you'll have to reach out to community corrections. Like I said, the order is already in place for you to have an OR bond with electronic monitoring because this case is so old. Again, you can contact community corrections if you have an alternate place to live, but I'm not going to let you go to a place and approve a place where there appears to be active drug activity going on. That's not going to happen. So you can reach out to community corrections and they'll respond to whatever requests you make. Okay.
Yeah.
All right. Thank you, sir.
Yeah. See, Mr. Parker on Delvin Jones.
Thank you, Judge.
This is Mr. Smith.
Mr. Smith standing in for Tommy.
Good morning, sir. Are you Delvin Jones?
Yes.
And Mr. Parker, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Jones, in cause number 19-33420, I have a motion to revoke your community supervision. Shows that you were placed on probation September 28th of 2020 for the state jail felony offense of credit or debit card abuse. That was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Yes.
This motion alleges that you violated your probation. In count 1, it alleges that you committed the new offense of theft of property April 17th of 2024 in Llano County, Texas. And is that true or not true?
It's true.
Did you enter your plea of true to count 1 freely and voluntarily?
Yes.
And because you actually did what they listed in there?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement is for me to continue your probation, extend
It 2 years, and at the bottom it says run concurrently with the probation in Llano County.
I guess, I mean, to say it runs concurrent doesn't really mean
Well,
it.
I understand. I mean,
Because if he gets off of that one early, it doesn't
Right.
mean he gets off. of
Right.
this
I
one
understand,
early.
Judge.
So so the understanding is to extend it for 2 years,
Right.
pretty much.
Right.
I just don't want that to make some
I understand.
agreement later
Right.
that we don't want to be bound by. So I'm going to mark through that runs
Okay.
concurrently
No
with it. And I see probation is here. Thank you, ma'am. And is that what you would suggest as well?
Yes, ma'am.
Okay, thank you. All right, then. All right, Mr. Jones, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation. However, I'm not going to do that. I'm going to give you this opportunity to remain on probation. I'm going to extend your probation for 2 years. Obviously, you're ordered to follow all of the rules and conditions of probation, especially you're ordered not to be arrested or charged or convicted of anything else. Not anything, but the fact that you picked up a theft after a credit debit card abuse gives me some concern because it's the same type of behavior. So this is a great opportunity. You will not get it again. Do you understand? You understand?
Yes.
All right.
He's on probation. He's in the Austin area, and I think they're aware of that. So
All right. So I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you've waived any right to appeal. And then if probation needs to talk to you before you leave, just make sure you talk to your probation officer. Hang on just a second. I'm waiting on something to print.
Out of 25. I need to.
yeah, okay. Not yet. Thank you, Judge.
All right. You stop and talk to probation right over there on your way out, please. Thank you.
Thank you.
Thanks.
Or signatures. So.
Huh?
All of them.
Great.
Pictures and I know they were not they all different things.
Units, and then it's filling my body.
Okay, yeah.
When you walk off, like just feeling it and then taking left, all the way down, it's possible sleep. But it's just hanging next to the struggling pain. You let me, Shane Hilton should probably.
Sorry, they're not in order. That's how they sent them to me. All at one time. Oh, just got, they just been on the pass. Absolutely. All 15. Wait, you're done. Oh, maybe I think I'll do some 2 days in class.
For what?
So just fight.
Well, yeah, I mean, why wouldn't you? You could just wear it and that's very frustrating. Yeah.
Also, family good.
Huh?
Would you like me to file a formal motion?
No. Mr. Burbank? Mr. Allen? Back on the record and cause numbers 25 DCCR 1163, 1164, and 1697. For whatever reason, Mr. Allen, we have not been getting updates with regard to your drug patch. And while you've had it on regularly, you've literally tested positive every single time. So I'm going back now. I mean, you tested negative today, but you've tested positive for cocaine starting back in December of 24. January of 25 tested positive for THC. The end of January of 25, again, positive for cocaine. First part of February 25, positive for THC. End of February, positive for THC. March of 2025, positive for THC. April, positive for THC and cocaine. May of 2025, positive for THC and cocaine. June of 2025, positive for cocaine. And so as frustrated as I am with you right now, I'm frustrated that I have a bond condition that I have had no idea that you've been violating and using marijuana and cocaine solid for.
I don't even use it. I guess it took me a little time for my system to be clean, but
It doesn't take 1.5 years for your system to get clean.
yeah, I know the last time I came in court, that was the last time.
No, at this point, I mean, I've got one from March 8th of 2026. So that's the one that they just tested, which they took, looks like off of you maybe March 3rd. So we're talking last week, you got one changed and it tested positive for cocaine. All right. So I'm going to find that obviously these are a violation of your bond conditions. The fact that you've been able to get away with it and this amount of time is ridiculous. I'm going to raise your bond in all of your cases. In each case, I'm raising your bond to $50,000 in each case. Condition of those bonds obviously is that you have a drug patch, but it's also that you not use drugs. So it's not okay to have a drug patch and test positive. That's not exact. You probably shouldn't.
I promise you ain't gonna see no.
It's too late. You can go back with the bailiff. Mr. Burbank will visit with you.
Go back to.
Yes, sir. That's insane. Well, lucky he didn't kill somebody, then it would have been me. All right, let's see, Mr. Lewis, you've got Crystal Julian. Y'all just wait just a second. Let me take, well, Yeah, come on up. Just. When did you use meth?
I haven't used meth. I've been around people. I've been using it. I stay with a girl. She's pregnant, and I struggle with.
So here's the thing.
Okay.
You're typically not going to test positive just for being in the same area.
Yeah.
Hold on. Okay. If you're that close to somebody using it, then you know better.
Yes.
And there's already an issue because you're here for a sentencing in clause number 25 DCCR 1393.
Mm-hmm.
And you've already have been on probations, felony probations that have been revoked. And in addition, you deny that you even knew what was going on the day. And so you denied the offense. And so for those reasons at this time, based on, I'm not necessarily saying I'm going to not accept the plea agreement, but what I am going to do is I'm going to raise your bond in your case today, and I'm going to raise it to $50,000.
Yes, ma'am.
We'll reset the case 2 weeks for sentencing. I'm not going to sentence someone if I think they're under the influence.
Yes, ma'am.
We've already got, I feel like, maybe not, hold on. Can they do a substance abuse evaluation in custody?
Oh, yes, ma'am.
How long would that take?
We can get it done this week. Should be able to get it done this week.
All right, so I'll reset the case 2 weeks. We'll get a substance abuse evaluation taken care of. And then if there's any recommendations based on that, then we will get that taken care of.
Yes,
If
ma'am.
you make that $50,000 bond,
Mhm.
a condition of it is that you have to wear a drug patch
Yes,
at all times.
Yes, ma'am.
I don't care who you're around, what you're doing. If it
Yes, ma'am.
tests positive, I'm going to have to assume that it's because you're using.
Yes, ma'am.
So if you're living somewhere where people are using methamphetamine,
Mhm.
you ought to not be living there.
Yes, ma'am.
Understood?
Yes, ma'am.
Go back with the bailiff.
Thank you.
Morning.
Good morning. It is a Monday. I agree with the current, with the earlier defendant. It's a Monday. He was right. I shouldn't have given him such a hard time for that excuse.
Thank you, set the tone for the whole day.
It's maybe we will blame him.
Yeah.
It's also the beginning of daylight savings.
It's all the things.
What did you say to stay like next time? She's Friday and 13th.
Oh, and, so, yeah, something else. I need another food action.
Oh, this week's Friday the 13th.
Oh, no. Almost.
We had a full moon last week. We have another one already.
It's daylight savings time. Let's do maybe the other way.
Stop. No, I can I vote no? All right. Are you Alexander Thornton? Just a second. And will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Thornton, in cause number 24, DCCR 0323, you're charged with a second-degree felony offense of fraudulent use or possession of a credit or debit card in an amount between 10 and 50, and that's from September 23rd of 2023. And how do you plead to that charge? Guilty or not guilty?
Guilty.
Okay, so you signed some paperwork here with your attorney, Mr. Barrington, for a plea of guilty with an exchange for a plea bargain. Is that not what you want to do?
Yeah, yes, ma'am, depending on the
depending on what the, my back time was.
So here's the thing. First of all, first thing is either you did it or you didn't do it. You don't get to say, I did it, but only if I get a great deal and whatever. Either you did or you didn't. So if you want me to accept a plea agreement, then you either take responsibility or we can have a jury trial. I mean,
Your Honor, is that, can I have a moment with my client?
yeah, sure. Because it looks like this is for that there's some credit that he will receive, but I'm going to make sure everybody knows if it's a plea for TDC that he's got to go into custody.
Yes, ma'am.
Okay. All right. I'll hold it for a minute.
Thank you.
No, y'all go talk in the, out there.
Okay, thank you. Plead guilty.
Y'all ready to proceed?
Your Honor, I am. Is that I'm going to need to make a record with my client.
Sure.
If I may. Mr. Thornton, would you please state your name for the record?
Alexander Thornton.
Okay, now, sir, a couple of weeks ago, the state made a plea offer to us of 3 years in institutional division of the Texas Department of Criminal Justice. Is that correct?
Yes, sir.
And at that time,
Additional more severe sanctions, which can include local jail time or prison. Do you understand that?
I do.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
I do.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
I do.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of their witnesses. Do you understand that?
I do.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
I do.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
I do.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
I do.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
I do.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
I do.
Do you believe you understand each of these rights we've discussed?
I do.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
I understand.
This is how you wish to proceed.
Yes.
Ms. Tranter?
On or about November 21st, 2025, Warren County, State of Ohio, the defendant Robin Lake did knowingly obtain, possess, or use a controlled substance, being cocaine, in an amount of 0.33 grams.
Mr. Huss, anything on those facts?
No, Your Honor.
Ms. Lake, did you hear the statement that she read?
I did.
Do you admit and acknowledge that what she said is true?
I do.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed.
I do.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty. Based upon the statement of facts and your plea, the court will make a finding of guilty. Now, I'm not going to get into the matter of sentencing today. I don't know enough about you to sentence you, so I'm going to order a pre-sentence investigation, and we will come back in a few weeks and do sentencing at that time. Anything else, folks?
Yes, one thing, Your Honor, she would like to be in a position to go back to work and have the routine she normally had before the case started. So if her home incarceration confinement could be adjusted to allow her to do that, she'd greatly appreciate that.
Are you at the coach right now?
I am doing community, so I go 9 to 1 Monday through Friday. So they have me still living at home.
Oh, okay.
Yes, I was assessed twice, and they recommended that both times.
Gotcha.
And I'm also attending NA meetings that was approved. My time, I'm doing that on my own as part of my recovery. I'm almost 60 days clean, and I'm have that approved with Conroy. So I just haven't been able to go back to work. I haven't worked all this year because I was incarcerated. And I don't want that to be a stressor on me where I want to, get back into my addiction.
Did you test this morning?
I did.
And what was the result?
It was positive for my Adderall, which I take for ADHD, and that was it. It was clean.
Do you understand why the court placed you on electronic monitored house arrest?
Absolutely. I would like to stay on the monitor as well, just because I think that helps hold me accountable. It's just.
Okay, that's what I was trying to consider. That's okay. That's fine. I appreciate that.
Sure.
All right, I will allow for work release.
Thank you.
All right, thank you all.
Thank you, Your Honor.
I went over that plea offer with you, and you said that you were interested in things out with some pending cases in Jasper. Isn't that correct?
Correct.
Okay. And so isn't it correct, sir, that we came before the court, told the court we were going to accept this deal, correct?
Correct.
And since that time, I've negotiated and discussed things in Jasper, is that and tentatively had a deal worked out for you up there, correct?
Correct.
Okay. And so then today we appeared here today, correct?
Correct.
Is the range and punishment is that, and so then today we appeared here today, correct?
Correct.
Is that I went over the paperwork with you, correct?
Correct.
Okay. Is that you signed the paperwork, correct?
Correct.
And it was the offer that the state made, correct?
Correct.
In that you, and I also went over the range of punishment with you in this case, correct?
Yes, sir.
Okay, and I explained to you that the range in punishment in this case is no less than 2 years and up to 20 years, correct?
Yes, sir.
And you also faced up to a $10,000 fine, correct?
Yes, sir.
And I also went over the fact of that you were going to have to plead guilty to this offense, correct?
Yes, sir.
Is that you signed the papers, right?
Yes, sir.
Okay. Is that, and then we got up here, is that in the court asked you how you pled, correct?
Correct.
And at that time, you informed the court that you were pleading not guilty, right?
Correct.
And we took a break and we went out in the hall, right?
Yes, sir.
Okay. And I discussed the fact of if you believe in your innocence, that you cannot plead guilty to something that you did not do, right?
Correct.
Okay. And at that time, you professed to me your innocence, correct?
Correct.
Is that, and I said, okay, do you understand that by pleading not guilty in this case, that the state is going to revoke their plea offer of 3 years, right?
Correct.
in that in all probability, we're going to have a jury trial in this case, correct?
Yes, sir.
Okay, and that you could, if you're, and that's going to be a guilt innocent phase, right?
Yes, sir.
And then with a jury of your peers, and then also going to include, if you're found guilty, a punishment phase, right?
Right.
And I explained all that to you, right?
Yes, sir.
Did you understand everything that I explained to you?
Yes, sir, I did.
Okay, and do you understand that if you persist in this, that this plea offer is off the table, we're going to trial? That's what the prosecutor's informed me.
Yes, sir.
Okay, and so do you fully understand the way these proceedings are going at this point?
No, sir, I don't.
Okay, well,
Here, let me.
Yes, ma'am.
I mean, I think anything further you need to get into is attorney-client
Yes,
privilege,
ma'am.
probably. So, Mr. Thornton, it's real easy. Either you enter a plea of guilty, accept responsibility for a plea offer. You could enter a plea of guilty, accept responsibility, leave your punishment open to the court, or you can go to a trial and let a jury decide. Those are your three options. So all I need to know is what you want to do. And I want to make sure you do understand that if you don't want this deal and you're not guilty, that's fine. That's what juries are for. But you will not get this offer again after today. So if we put it on the trial docket, it will be expected to go to trial. If you change your mind later, it will be to some different either plea agreement or open to the court. You understand?
Yes, ma'am.
So what part do you not understand?
Well, Your Honor, if I could, maybe feel free to explain.
Well, here's what I don't want you to do. I don't want you to talk about the facts of the case. Okay. I'm taking a look at the probable cause. I have a very limited understanding of what the allegations are. That's kind of not my position right now or what I need to be getting into. That's for either a jury. But your attorney, Mr. Barrington, obviously knows what the state's evidence is and what they would put forward at a trial in front of a jury. So that's important for you to discuss with him. You have every right, again, to have a jury decide if you're guilty and what your punishment would be. And what do you want to do?
I would like a jury trial.
All right. So I'm going to delete this paperwork. We'll set your case on the trial docket. I'm going to make a notation. I don't necessarily need a rejection since we've really kind of gone through this. There will be a notation of what this offer was. And again, that offer's off the table after today. And we'll get your case on the trial docket. Mr. Barrington will be in preparation for trial. All right. You're free to go. Thank you.
Thank you, Your Honor. May we be excused?
Yes, sir.
Thank you.
I don't know if y'all could do kind of a memo, like this kind of memo, because technically there's not a rejection.
The previous rejection was for 4.
It was. I'm going to go make a notation on that one. That's what I'll do.
He's not getting anything. And no one is expecting any more. So
Working on the budget.
There's one for that one that I do. And that was on the initial document.
All right, so it looks like the only thing we've got left is waiting on Mr. Ward, who said he'd be here around 10:30. So he should be here soon for Mr. Thibodeau's case.
Que esté presente que necesite los servicios de un intérprete.
They have Abdullah Corbani, but that's not Spanish, is it?
No, it seems not. I see this person named Elias Hernandez. You want me to direct the question directly to that person to see?
He doesn't need one.
Oh, okay, no.
While you're here, why don't you ask him just for good measure?
Hola, en este momento, señor Elías Hernández, si usted acaso necesita los servicios de un intérprete.
No, I don't need it.
All right. Well, you've done what you could. Thank you, sir. You may go.
Have a great one, Your Honor. Thank you for using the services.
You're welcome. Bye-bye.
Thank you, guys. See ya.
Bye-bye. Thank you, Mr. Bondsman. We'll be in recess on Portillo. Ms. Schmidler, who do you want to take up?
I just have Mr. Hernandez Rodello.
All right, well, let's take that up. We'll be on the record in BU 2025 TR 2075, State of Kansas versus Elias Hernandez. I was waiting for the interpreter. All right, please announce appearances.
Jared Regier on behalf of the state.
Good morning, Your Honor. Bailey Schmiedler appears for Elias Hernandez Rodella, who's present on Zoom.
And do we have any announcements on this matter?
Yes, Your Honor, we've reached an agreement with the state. Mr. Hernandez intends to plead guilty to no valid driver's license. In exchange, the state will be dismissing the other infraction. The parties will jointly recommend a $300 fine and court costs, underlying sentence of 10 days and 6 months of non-reporting probation.
And that's your understanding of the agreement, Mr. Regier?
It is, Your Honor. The state, upon successful entry of a guilty plea to no valid driver's license under KSA 8235, the state would move to dismiss the remaining count and recommend a $300 fine, court costs, and a 6-month non-reporting probation. The state does acknowledge that count 1 of this matter does appear to be charged as a Class B misdemeanor. However, the state's information is that KSA 82117 applies in this matter. Therefore, the state will be recommending a suspended 10 days, the maximum permitted by law in a juvenile detention facility.
Instead of, oh, okay. All right, so how old is your client, Ms. Schmidler?
I believe he's 15, almost 16, Your Honor.
All right. Mr. Hernandez, how do you plead to count 1 operating a motor vehicle in Butler County without a valid license on August 29th of 2025?
Guilty.
By pleading guilty, you're admitting that you did do what you're accused of, driving without a license?
Yes.
Were you 15 while you were doing that driving?
Mm-hmm.
Had you ever taken a driving test?
No.
Where were you doing this driving?
I was heading to school.
What road were you on when the officer stopped you?
I don't remember.
This was just in August of 2025. You don't remember where you were going, how you were going to school, what road?
No.
What school were you going to?
Say that again?
What school were you headed towards?
Rosehill High School. 159th, I think.
Were you on the road?
Yeah.
This says Southwest 180th and Country Club Road.
I think that, yeah.
So do you live in El Dorado?
No, I live in Rosehill.
You live in Rose Hill and you were going to which high school?
Rosehill High School.
Oh, Rose Hill High School. Okay. You live in Rose Hill and you were headed to Rose Hill High School. Mr. Regier, your evidence would show, according to this citation, Southwest 180th and Country something Road.
County Line.
County Line. Oh, thank you. County Line Road. Okay, now I know where, I think I know where you were. That's gravel, isn't it?
Yeah.
And you were 15. Did you ever have any driver's ed courses?
No. But I have my permit on me right now.
But you didn't have a permit then?
Yes.
Yes, you did. Or
Oh, no, I didn't.
Is anyone making you enter this plea today by any threats or promises other than your plea agreement?
No.
You understand you have the right to a trial, but you're giving up that trial with this plea?
Yes.
And this did happen August 29th of 2025, about 7:46 in the morning?
Yes.
All right. Did your parents provide you the vehicle to drive?
No, I took it.
Did they know you took it?
No, they were asleep.
How were you supposed to get to school that day, according to your parents and your conversations?
I was going late to school and I took it because I didn't want to fall late and get in trouble at the school.
Were you supposed to ride a school bus or anything?
Yes, but I missed it.
Oh, instead of telling your parents you missed the bus, you took the keys in one of their vehicles?
Yeah,
And you'd never driven before, or had you?
No, I haven't.
Yeah. Nice. Now you have your learner's permit.
Yeah.
And you're still driving to school?
No, my mom's taking me.
All right. Well, per your plea agreement, your fine is $300. Your court costs are $108. Do you have any kind of job or savings to pay this total of $408?
Yes.
Did you receive any discipline from your parents?
Yes.
What was it?
I got grounded.
For how long?
I'm still grounded.
What'd they ground you from?
Video games and my phone.
So you've been without video games and your phone since August 29th to 25?
Yes.
Okay, are your parents here?
Yeah, my mom.
Okay, well, all right. I'm going to give you the 10 days to be served in a juvenile detention facility, a locked facility. But since your parents have taken the responsibilities they have, I'm going to give you a 6-month probation. You won't have to serve that as long as you don't violate any more laws, that you attend school when it's in session and you make grades at least C's and above.
Okay.
And what can we do to get you, not your parents, but you, to pay this 408? Do you have any kind of means to make that money?
Yeah.
What will you do?
Work with my dad.
What kind of work's your dad do?
He does construction with his own company.
And he's going to let you work for him and pay, then you'll take what you make from him and pay the fines and costs.
Yes, ma'am.
Have your parents given you any lectures on why this is bad? How
Yes.
people could have been killed? And then you'd be looking at worse charges. Have they talked to you about all that?
Yes.
All right, then I won't do it. Ms. Schmidler, I trust, has given you some ideas about how this was legally wrong and so forth and what could have happened. So, all right, Mr. Regier, anything else?
Your Honor, if the court is finding that the defendant has successfully entered a guilty plea to count 1, the state would move to dismiss count 2 pursuant to plea negotiations.
Oh, that's right. You wanted to dismiss count 2. Okay. I'll dismiss that per your plea agreement.
Your Honor, will you have 30 days to make payment?
30 days is fine. If that's what he needs, I'll definitely give him 30 days.
Yes, please. Thank you.
You're welcome. Mr. Hernandez.
Yes.
Just one word of caution. I'm going to forego the lecture I'd like to give you because I'm trusting you've already had it and I think you need it, anyone in your position. But a word of caution, stay out of trouble so you don't come back here and see me, because you've got some juvenile detention time hanging over your head in this case. And I'm not going to be really encouraged if you get in trouble anymore. You might get some significant penalties on another matter if you get in trouble. But I definitely don't want to have to impose that 10-day sentence. But if I have to, if you make me, I will. So get to school, don't skip, but keep your grades up, because I hear about that kind of stuff too.
Yes,
Don't
ma'am.
get in fights, that kind of thing, if you can help it. All right. If there's nothing further, Ms. Schmidler,
Nothing further. Thank you.
you're welcome. Mr. Aguirre.
Not from the state, Your Honor.
All right. You may go at this time, Mr. Hernandez.
Thank you.
You're welcome. Who do you have, Deputy Caulfield?
I have Landon Williams.
Landon Williams.
It's Mr. Patterson's. He also supposed to be up in court in A and at 10:30, so I thought we might ought to get him out of the way.
Mr. Patterson or Mr. Williams?
Williams.
Myself, Your Honor.
I wasn't aware of a court hearing at 10:30, Judge, so I hope it wasn't.
No, Mr. Williams is supposed to be.
Well, 10:30. Okay. Is that Central Standard Time or daylight savings? Never mind. We are on the record in 25 CR 537, State of Kansas versus Landon Bryce Williams. Please announce appearances.
Thank you, Your Honor. May it please the court, Joseph Baca appearing for the state of Kansas.
Your Honor, Darren Patterson appear on behalf of Landon Williams. Mr. Williams does appear from Courthouse Security 1 video station. Judge, this is a case where Mr. Williams is applying for diversion. He has submitted the diversion application with the diversion fee. We're just waiting to hear back on whether he's been accepted or not. Would ask for continuance, Judge.
Mr. Baca?
Your Honor, I was just checking to see if we had anything. I certainly don't object to the continuance. I'm not seeing any information on the diversion, but I'm sure we're working on that and we'll be getting that out shortly.
All right. You still live in Cherokee, Oklahoma?
Cherokee, Kansas, Your Honor.
Oh, the docket notes say Oklahoma.
I do not know why it shows Oklahoma, ma'am.
You're down by close to the Oklahoma line there in Pittsburgh or Missouri?
Yeah.
Corner.
Yes, Your Honor.
Are you still a student at Butler County College?
Yes, Your Honor.
So you're still in this area, in El Dorado area?
Yes, ma'am, Your Honor.
Having no contact with the alleged victim and witnesses?
Yes, ma'am, Your Honor.
All right, Mr. Baca, what was the state's position on this request for continuance?
No objection, Your Honor.
All right, now how much time are you asking for, Mr. Patterson?
Just whatever the court has available next.
All right, Jennifer, what do we have?
May 18th, Your Honor.
All right, May 18th. I'll continue this at your request to May 18th at 9 a.m., Mr. Williams, with all the conditions on your bond to stay in place.
Yes, ma'am.
Society condition to be back here May 18th. All right, and if there's nothing further, you're excused, sir. You may go.
Thank you very much, Your Honor. Have a nice day.
Okay.
Thank you.
Okay, Judge, I have 7 more Mr. Pattersons and I have 2 pro se's.
Mr. Patterson, you want to take up another one of yours?
Yes, Judge.
Stephen Davis.
Stephen Davis. We are on the record in 25 TR 2835, State of Kansas versus Stephen Maxwell Davis, Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Mr. Patterson, announcements?
Judge, this is a case where this is the first time I'm appearing with Mr. Davis. I have discussed with him issues concerning his driving record, and he is going to give me some more information. So I would ask court to allow one continuance on this.
State's response?
No objection, Your Honor. If the court is prepared to continue the bond in this case, it would appear that Previously, a bond had been executed in the amount of $2,000 professional surety. State would further be request the court making a finding that this is a defense request for continuance for speedy trial purposes.
This is continued at the defendant's request. Mr. Davis, you will be continued on that $2,000 bond you posted in December. All existing conditions and the added condition that you next appear. Jennifer, is it May 8th again?
May 18th, Your Honor.
Must be back here May 18th at 9 a.m., Mr. Davis. Make sure Mr. Patterson can find you when he needs to discuss your case.
Yes, ma'am.
Anything further from anyone?
Not from the state, Your Honor.
Nothing further, Judge.
Very well, we are in recess on Davis. You may go, Mr. Davis.
Thank you.
Yes.
I have a Kyle Rogers that is stating that he has court coming up. Another court date today.
He needs to be in front of another judge. Come on. It's not a good sign. All right, we'll take you up, Mr. Rogers. Where are you? Where is he?
Well, it appears maybe he has left.
Maybe he already had to go to the other court. All right, well, we tried. Who do you have?
Kevin Lane.
Kevin Lane. We are on the record in 3 cases. BU 2024 TR 3340, BU 2025 TR 2067, and BU 2025 TR 2537. Each case is captioned State of Kansas versus Kevin Charles Lane. Jared Regier for the state on each of these, and Mr. Patterson appearing for the defendant on each of these. Defendant appearing in person, all via Zoom, separate locations. Mr. Patterson, announcements, if any?
Judge, as the court can see, there are 3 different cases that I'm trying to work through, and it has not been an easy task. So I can tell the court that I am not in position or ready to announce a final disposition, but ask the court for a continuance.
State's response.
One moment, Your Honor. No objection, Your Honor. If the court is prepared to continue the bonds in all 3 cases, subject to all pre-existing conditions, it would appear that at the last setting on December 29th, the court did order that the defendant shall report weekly to court services as directed by the court services officer. State would request that those be the continuing orders of the court, given the interwoven nature of these 3 cases.
Have you heard any indication that he's not following that condition of bond? Court services, have they advised you that he is or is not attending?
Unfortunately, Your Honor, I have no additional information to add at this time.
I talk to the court services, Ryan, every Friday morning at 8:30.
All right. Well, Mr. Lane, you have 3 driving while suspended in this court, it looks like. And now, were you one of them? They said had something going on in another court. That wasn't you, was it?
What's that?
Never mind.
It was the person before, Judge.
Okay, just want to make sure it wasn't this one too. All right. So what did you want to set this over to how that next court date, Mr. Patterson?
Yes, Your Honor.
All right. What you want to say that date again, Jennifer? May 18th?
For this one, since it's 3 cases, we're going to have to set this to June 1st.
All right.
The May 18th only has 1 left.
Okay, thank you. All right, Mr. Lane, all 3 of your cases at your request are being continued to June 1st. You must be back here June 1st at 9. And I'm going to continue all the bonds you're on with the conditions that you already have Make
Okay.
sure you don't get any more violations of the law. You're going to probably have to sit in jail until we get this resolved.
Yes, ma'am.
Okay, so who did someone bring you to court today?
No, yeah. My son.
All right. As long as your son has a valid license and wasn't that 15-year-old.
He does.
Okay. All right. So continue at defendant's request on bond June 1st, 9 a.m. Be back here and be available if Mr. Patterson needs you.
Okay, thank you, Your Honor.
You're welcome.
Judge?
You're excused. Yes.
Do you want these at 9 or 8?
Well, Mr. Patterson, what do you want? Let's get a question.
8 o'clock, Judge.
8 o'clock. Okay. 8 o'clock.
All right.
Thank you.
Okay. Okay. I have Lori Hussman coming up next.
Okay.
And Jared, what I've requested, is that acceptable?
One moment, Your Honor.
Thank you.
I'm coming. It just takes me a bit. How are you today?
Your Honor, the state is prepared to proceed in this matter.
Very well. We're on the record in 23 TR 1473, State of Kansas versus Lori Ellen Hussman, Jared Regier for the state, Darren Patterson for the defendant, who also appears in person, all via Zoom, separate locations. Mr. Patterson?
Your Honor, would announce this time that Ms. Hussman would be entering a plea of guilty to no proof of insurance, Class B non-person misdemeanor. State's agreed to dismiss the remaining charges.
So that is pleading guilty to count 3
Yes, Your Honor.
and dismiss 1 and 2. That's your agreement, Mr. Regier?
That is the state's understanding, Your Honor.
And what will your sentencing recommendations be?
Your Honor, pursuant to plea negotiations, the state would be recommending a $300 fine, the minimum required by law, that the court impose appropriate court costs and determine attorney fees. State would further recommend a suspended jail sentence of 120 days, subject to a non-reporting probation of 6 months.
And that is your agreement, Mr. Patterson?
Yes, Your Honor.
Ms. Hussman, that's your agreement?
Yes, ma'am.
How do you plead then to count 3, operating a motor vehicle on a highway or roadway open to the public in Butler County on February 11th of 2023 without proof of insurance?
Yes.
How do you plead? You can plead guilty, admitting the charge.
Guilty, Your Honor.
You can also plead not guilty, denying the charge and taking it to trial, or you can plead no contest, not admitting it, but not denying it. You'd still be found guilty. But you want to plead guilty, is that right?
Yes, ma'am.
So you're admitting that you drove without insurance on February 11th of 23?
Yes.
Is anyone making you enter this plea of guilty? By any
No, Your
threat?
Honor.
No threats, no promises other than the plea agreement?
Yes, nobody's making me plead.
All right, you understand you are giving up your right to trial and you will be found guilty?
Yes, ma'am.
You won't be able to appeal your conviction. Do you understand that?
Yes.
All right. And you're pleading guilty because you believe you are in fact guilty?
Yes.
All right, I'm going to accept your plea and find that you knowingly and voluntarily entered the plea of guilty to driving without insurance in count 3. Finding you guilty of count 3, I will dismiss on motion of the state per plea agreement counts 1 and 2. And I will follow your plea agreement for your fine, $300 fine, $108 court costs for a total due of $408. Do you work, Ms. Hussman?
Yes.
Where do you work?
At Salon Boutique.
Okay, and do you know what you make there per month?
Right now I'm only bringing home about $125 a week.
Okay, married or single?
Single.
All right, I'm going to waive your attorney fees. How much time will you need to pay $408 total?
As much time as you can give me, Your Honor.
About 120 days, would that be helpful?
Yes.
All right, I'm gonna give you 120 days. Stop by the clerk's office and they'll tell you how to make those payments. They're right across from the security guards, the metal detectors. Now, I'm also giving you a 120-day jail sentence, but I'm not going to make you pay that as long as you successfully complete a 6-month non-reporting probation. Condition 1 is that you violate no laws for the next 6 months. Condition 2 is that you pay the total of $408 within 120 days. And I believe that is it. Anything further, Mr. Regier?
Not from the state, Your Honor.
Mr. Patterson?
Nothing further, Judge.
Ms. Hussman, anything further?
No, ma'am.
All righty, then you may go. And if you have any questions, just give Mr. Patterson a call. He can probably answer them as well as anyone.
Yes,
Okay. So, the vice chair. One more?
a little lane.
Okay.
24 CR 1699 is not called the state of Texas versus Michael. Sam, you're Mr. Sam. Yes. And you're here with Mr. Dusler. Is that your final answer?
Yes,
Don, you got the plea papers? She didn't have none. I did them. There's the hold up on that. Trying to fire up the tablet when else they're closed, but I get it. Probably the tablet's fault. No, it's my fault. It's always been the tablet up to now. I'll take blame this time. All right, in 24 CR 1699, Mr. Sam, can the court proceed in summary? Yes. You were here with Mr. Dusler, you were attorney, the state's attorney. In summary, my goodness. We got a page full of facts here. Yes, sir. You don't want to be called a thief. No, sir. But I've got 10 prior theft convictions here. So, sir, that was in the old days? Yes, sir. This one was to out of this. My mom, I don't think 2022 was in the old days. No, that one would. And then you got this one now in 24. All right. In summary, paragraph 1 alleges that on or about May 12th, 2024 in Jefferson County, Texas, you committed the offense of theft. And paragraph 2 goes on to allege that you have 2 or more theft convictions out of district and county courts at law. And once you have 2 or more theft convictions in county courts of law or district courts, if you steal a pack of gum, it's a felon from here on. And actually, you've been a subject to felonies looks like since 2008. So it's time. That's a lot of time. Um, 18 years. Yes. So you were looking at a state jail felony, which carries with it no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can also be assessed. Maybe for my. There it is. Do you understand what you are charged with and the punishment range that's applicable in this case? An agreement has been reached where you would be pleading guilty, sentenced to 14 months in the state jail. Is that your understanding of the agreement? Yes, sir. If I follow this agreement, you have no right of appeal of your case. Do you understand? Yes, sir. How do you plead in this case, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will? Yes, sir. And because you are guilty? Yes, sir. I'm going to show you here what's marked as State's Exhibit 1. Did you sign this document, understand it, discuss it with your attorney, or the contents all true and correct? You are mentally competent to enter your guilty plea. It's freely and voluntarily. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. So help you God. Yes. States Exhibit 1, part of the record for all purposes. Let me ask you on paragraph 2, which are these prior convictions of thefts. The last two allege that on or about January 24th, 2019, out of the 412th District Court of Brazoria County, in cause number 84434, you were convicted of the offense of theft. And the next allegation, which is the last one of all the priors, alleges that on September 9th, 2022, which would be over 3.5 years later, in the 461st District Court of Brazoria County, you were convicted of theft in cause number 95842. Is all of that true and correct as it is alleged? Yes, sir. And are you pleading true and correct to those allegations voluntarily and because they are true? Yes, sir. All right. Not a good sign when you're starting off using whiteout on the first case. That's not good luck in Haiti, from what I read. Yeah. If nothing further, I'm going to find you are pleading guilty to paragraph 1, alleging theft on or about 2024, May 12, 2024. You are pleading true to allegations, the last two allegations of convictions in the 412th and 461st District Courts of Brazoria County, Texas, in 2019 and 2022, respectively. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting the guilty pleas from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of the jail felony in paragraphs 1 and those two prior convictions in paragraph 2. I now find you guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You were hereby sentenced to confinement in the state jail for 14 months. You will be given credit for all time you're serving in accordance with this case. Do you understand what has happened today, sir? Yes. What are you doing about this now? It's a long time. It's time you became an honest man. Yes, sir. Okay. Good luck. Thank you. Do it. Make your choices. Yes. Listen. Martin. Here we go. Thank you. Okay. Long talk was it? August 5th, 2020. Swear in front of this lady here in a minute. Thank you. Yeah, we'll do it. Can you sign this?
You're right, right now. That's right. You never work out these? That's it. You just need to judge.
All right, we've got two cases. What are we going to do? What's a,
We're gonna put it through the counts 1, 2, and 3
in each case?
in each case, and then we're gonna ask that an updated PSI is a half of 12 months state jail.
A whole bunch of misdemeanors, Jeff.
Just misdemeanors.
All right, 21-36529 and 36760 are both called. The state of Texas versus Averiana Ladelia Beverly. Did I get that right?
Yes, sir.
That's you, with your attorney, Mr. Burbank, and the state's attorney. There are two first amended motions to revoke unadjudicated probation filed in January 28th. Does the defendant waive formal readings of these, and can we proceed in silence?
She does, and you may,
And does the defendant waive any additional time that she may have from the filing of these motions to proceed today?
we waive in each case.
Hold on. Ma'am, please raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lord. In summary, 36529 states that on May 3rd, 2022, in this court, you were placed on 5 years deferred or unadjudicated probation for burglary of a building, a state jail felony. Is that all true and correct?
Yes.
And in 36760, this alleges that also on May 3rd, 2022, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of theft. Is all of that true and correct? Which ones? Allegation 1 in each case states that on or about August 5th, 2025, in Jefferson County, Texas, you committed the offense of unlawful carrying of a weapon in violation of your deferred or unadjudicated probations in each of these cases. Is that true and correct?
Yes, sir.
Number 2 states you committed the offense of illegal possession of a controlled substance on or about August 5th, 2025 in Jefferson County, Texas. And is that true and correct as it is alleged?
Yes, sir.
Doesn't say what the
Methamphetamine.
methamphetamine. Was it methamphetamine? You don't know?
That's one of many, Judge.
Just one of them. There
It
was
was some cocktail of a group of it. Okay, including methamphetamine.
Yes, sir.
3.
same thing, just saying.
Okay.
Same day.
Okay.
We can just do 1 and 2. That's fine, Judge. If she's taking the plea.
Well, let's just do 1 and 2 because they're worded the same way, but it's stating illegal possession of drugs, but it's not describing what the drugs are in each case. They're word for word the same. So are you pleading true then to allegations 1 and 2 of each of these first admitted motions to revoke unadjudicated probation voluntarily and because those allegations are indeed true as they are alleged?
Yes.
Do you understand that a knowingly and voluntarily made true pleas in 1 or more cases, that is enough to grant a motion to revoke probation? Your probations could be revoked. You can now be found guilty and sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, you insist on pleading true to that. I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true in each case.
Hey, I got good work on it. Right.
When you The agreements in each of these cases are whatever sentence shall not exceed a cap of 12 months or 1 year in the state jail in each case. And these cases would run concurrently. Is that your understanding of the plan?
Yes, sir.
If I follow these agreements, you have no right of appeal of your case. Do you understand?
Yes.
Words can't describe it. What you have to do to erase something, which
That's the good old days when you just turn the pen upside down, erase it like an eraser.
nope.
I think he's totally screwed up the food package.
Oh,
There it is. Whoever buys this, I think they come from another country and they're working to overthrow this country. That's because there's just no way this is practical. And again, if I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
What we're going to do in each of these cases is do a pre-sentence report.
Yes, sir.
And we'll come back and each party will be able to add additional information for the court to consider. And then the court will make its ruling. Then, do you understand that?
Yes.
How long have you been in jail now?
December 17th.
I think I'm going to hurt this. Very interesting. It's actually my stop, guys. Sure.
It's not even 10 o'clock in the morning.
The day when gets to stop, hopefully it's Terry to fill in time before you correct the way forward.
Another thing, I'm going to show you what's marked.
It's marked.
There. Just marked in each case as States Exhibit number 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents all true and correct? States Exhibit 1 is tendered into evidence in each of these cases. Without objection, it's admitted. This also states if I follow these agreements, you will have no right of appeal of your cases. Do you understand?
Yes, sir.
All right, we're going to reset this. We'll see you back here in how much time do you think?
4 weeks.
Is 4 weeks good?
Yes.
Okay, thank you.
Let me see.
Bart Thibodeau, Mr. Ward, Ms. Malfino. Good morning, sir.
Good morning.
And sir, you're Bart Thibodeau,
As well.
and will your client waive the formal reading of the indictment?
He does.
Mr. Thibodeau, in cause number 25 DCCR 0339, you're charged with the state jail felony offense of solicitation of prostitution from December 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Hang on, I'm sorry.
Yes, ma'am.
I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you sign these, did you go over them with your attorney?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 4-year deferred probation. There would be a $1,000 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding? I'm sorry?
Yes, ma'am.
And is there going to be a dismissal in the other case? What is the?
Yes, Judge, at sentencing, if the court will allow, I also would like to request a substance abuse assessment. I don't have reason to believe today that there will be a positive test. I know the court has other members to attend to this morning, but that will be part of any plea negotiation.
So with everyone's permission, I just want to, it's not on the plea bargain agreed recommendation page, that it is the agreement to dismiss that. Clause number 25 DCCR 0755. Is that your understanding? Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thibodeau is not competent?
None.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and we'll come back later for sentencing. I am going to ask them to do a substance abuse assessment as well, just to make sure if there's any issues that need to be addressed on sentencing and while you're on probation. Today, when you leave the courtroom, you need to stop and talk to probation. She's at that desk right over there, and then we'll see you back at sentencing. All right, you're free to go. Thank you.
Thank you.
Oh, sir, I need your discovery certification before you leave. There's a in the box right there on council table. If you'll get your signature and your clients, and then we'll need you to talk to the DA and forward the exhibit that's supposed to be attached to it. But I need that one today, please. Thank you. You need the other Miranda, please. Morning. Good. All right. This is cause numbers 25 DCCR 0386 and 0387 on Ray No. Could I just?
They're in the corner.
Okay. Mr. Franklin, Mr. No. Good morning.
Good morning, Your Honor.
All right, sir, you're Ray No.
Yes, ma'am. Good morning, Your Honor. I'm Ray No.
Usually it's the other way.
Yeah, that's what I was thinking. Over here.
All right, and so Mr. No was previously in court in cause numbers 25 DCCR 0386 and 0387, entered pleas of guilty to intoxication, manslaughter, as well as driving while intoxicated with a child less than 15 years old. That was an open plea to the court. We had gotten started a little bit on this hearing, and then I reset it so that the state could, or anybody could bring any witnesses with regard to statements in the PSI and sentencing. We've all had an opportunity, correct, to review the PSI.
State has you. Yes, Your Honor.
Other than what we've already discussed and what the defense has filed with regard to response and objections, anything else with regard to the pre-sentence report?
Not from the state, but not at this time, Your Honor.
Okay. Obviously, with regard, well, when we get to after witnesses, we'll go through the pre-sentence, what the specific objections are. I think primarily the big part of it was witness statements outside of court. And so we'll hear what we hear today, and then we'll go through any prior criminal history that I feel like is important and admissible, and we'll talk about all that at that point. Is everyone ready to proceed?
Yes, Your Honor, we're ready.
And I will take judicial notice of the court's file. It does include, obviously, the pre-sentence report. It includes the defense response and objections to that, as well as the state's sentencing memorandum as well. And is that it? I think that was filed. There was also a letter from Joyce Barnes, the mother of the defendant, and I have that as well.
Your Honor, I think we had also previously filed letters of support, which the court had reviewed.
Okay, I think I've got those.
We did not refile them.
That's
for purposes of sentencing.
sure. Okay, if you'll take a look in the file and make sure. I feel like I've seen them all, but I don't have them printed out. If you'll just check and see if they're where they are. Okay, Mr. Coleman, there's. Go ahead. You wish you have a witness.
The state calls Trooper Angel Campos.
Trooper Campos. Good morning, sir.
Morning.
You please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can have a seat.
Would you please state your full name for the court reporter, please?
Angel Campos.
And
Can you pull that microphone a little closer? Yeah, thank you.
Trooper Campos, how are you employed, sir?
I'm employed to the Texas Department of Public Safety.
And how long have you been with DPS?
I've been with DPS today almost 3 years.
Okay, and certified peace officer, correct?
Yes,
And your training and background, of course, includes the academy. I understand you also have some military background as well. What does that include?
I do. I'm working on my 11th year serving in the Marine Corps. And currently I'm a Staff Sergeant E6 in the Marine Corps today.
Okay. I'd like to take you back to December the 11th of 2024. Were you working that day?
I was.
At around 7:56 or so, were you dispatched to a crash?
I don't remember the exact time, but roughly around that time, yes.
Did you bring a copy of your report?
I do not know. I left my laptop with the.
Is it on your laptop?
It's on my laptop.
John, can we retrieve that laptop? I'm sure he's gonna probably.
Sure. And if we can, do you have a hard copy, Mr. Do you have a copy, Mr. Franklin? I'm sure.
I have.
I do not have a copy of the.
I have one.
But it was a discovery.
Yeah, of course.
It was produced, Your Honor.
Okay.
Okay. You remember this crash, right?
I do.
And if you want, you can, let's do this. If it's helpful for him to use his computer, that's fine, but let's get a hard copy for defense counsel. Everybody can have a hard copy. We can make copies if we need to. I'm assuming, do you want a copy? Are you okay?
Yes, Your Honor, I'll take the copy. I've got notes on all the relevant portions for myself.
Okay.
I didn't have a copy.
Okay. If you have it, fine. If not. Let's do this. Why don't you just have him go ahead? He can pull it up on his computer and no, that's okay. If anybody needs a hard copy, then we can work on that at that time. You can let him work off his computer. You don't have any issue with that, do you?
No.
Okay.
I probably just for record's sake, I'll ask him if that's all he's looked at.
Yeah, sure.
You have it pulled up. Just let me know if
He's loading up. All right, I'm good now.
All right. December the 11th, 2024. Did you receive a dispatch around 7:56 or so?
Yes.
What was the nature of that dispatch?
Initially, it came out to a 2-vehicle crash on Spur 93 near Hillenbaum Road.
Hillebrand Road,
Yes,
and that's in Beaumont, Texas, correct?
it is.
Jefferson County, Texas.
Yes.
All right, and please briefly, the judge will see the video here in just a second, but briefly describe for the judge what you observed when you made the scene.
Initially, when I made the scene, I was expecting, like I was dispatched to two vehicles. Then I later found out the two vehicles that I rode up on, one was the deceased's vehicle, and the other one was the witness that witnessed the entire crash. I didn't see a third, but I couldn't really comprehend what had happened because I couldn't find the car that did everything. And then I later found out through on-scene personnel that the vehicle that caused the crash was further down the road, upside down.
Did you make contact with the driver or the operator of that vehicle?
I did.
And was he identified?
He was.
Who was he identified to be?
Ray Anthony Noe.
Okay. And was the vehicle that that the defendant Ray Anthony Noe was driving, was it also, did it have any passengers in it?
It did.
And how many, and what was their age in relationship to this defendant?
It was his child. I want to get the age exact. I don't remember exactly, but he was around. I think he told me at the scene here that he told me he was 9 years old.
Okay. And through your investigation, did you determine if that child was restrained in that vehicle during the crash?
Yeah, the investigation determined the child was not restrained at the time.
When you made contact with this defendant, we're not going to spend a lot of time on it because he's already pleaded guilty, but nevertheless, you observed signs of intoxication, correct?
Yes.
Did he refuse or did he consent to a blood draw?
He refused.
And you obtained a blood search warrant, correct?
I did.
And his blood was drawn pursuant to that blood search warrant.
Yes.
What I'd like to ask you about next and explain to the court is this defendant's demeanor. How would you characterize this defendant's demeanor there at the scene and at the hospital as well?
So his demeanor.
Your Honor, I'm going to object to this to the extent that he's required to, that it's asking him to opine because he has not been established as an expert on opinion that he can. I don't have an objection to him observing what his observation, but to the extent he's going to opine, we're going to renew our objections that we've already made in our response to objections.
That's overruled. He can testify as to what your opinion is as to his demeanor that evening.
Please go ahead and answer true.
The demeanor on that night, he refused to comply with almost every order we gave him. We had tremendous amounts of patience to try and do our job, and he made it every bit difficult, to include the omittance of, allowing us to prove. I even asked him on scene if he could let me do centralized field sobriety test so we can rule out his intoxication, and he refused that too. Try to give him a chance there. Try to give him a chance to consume blood, and he refused there too. Did every trick. Well, it appeared like he was trying to buy time for himself, and he, through my training and experience, we kind of pick up on tricks that DWIs do, and it appeared like he was utilizing everyone he could at the time.
Yeah, and I'm sorry to interrupt, but we're talking about more than just a refusal or.
Yes.
I'm John Dixon.
He's a bleeder.
Come on up, please. John Dixon.
He's in custody.
John Dixon is next. Thank you. Police is going to do on. Now,
I'm requesting a 3 to 4 week resetting on that.
3 to 4, 3.5 weeks. I was right in the middle of it. 3 to 4.
Then you speak with Ms. Porter on that. She just won the case with me.
Okay, Malbro's 3 cases will be postponed, reset for, did you say 3?
3's fine.
3's good. Darren Middleton.
You reset it. That's what I wanted about Tim for him. And
Devon Westbrooks.
I believe so was missing more about that. So that was, I mean, all those places ago. So that's maybe. Yeah. Sorry.
Right. That's you because she can give it 3 weeks on Westbrook.
Two's good.
Right.
Same number.
Right. And you are. I got you. 24 CR 2417 is now called the state of Texas versus John W. Dixon. Is it William? Wayne. Dixon, you were here with Ms. McNally, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on November 2nd, 2024, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon, and this was mainly a firearm. You understand what you were charged with here?
Yes, sir.
If convicted, this is a second-degree felony, and you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would, whatever sentence shall not exceed a cap of 10 years in prison. So you were looking at no less than 2, nor more than 10 years confined in prison. I guess deferred or unadjudicated probation can be assessed. And he can also get regular probation on this one, right?
Not from you, Judge. He
but
would
from
be,
a jury, he
he
could.
would have been eligible for a degree, that's correct. But you can only give deferred.
All right. Those are 2 options.
Yes, sir.
Deferred or unadjudicated probation and a flat time, no less than 2, no more than 10 years confinement. If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this indictment, sir? Guilty or not guilty? Are you pleading guilty voluntarily?
Yes,
That is on your own free will and because you are guilty. Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
State one.
State 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. If you've read it, you were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. We are going to order a pre-sentence report. We will all return back on
April 13th.
April 13th, just in time for taxes. And everybody can sound in and the court will make its decision. Okay, good luck.
Thanks, Judge.
We do this back at the court, the system from this is. Which is not have my own salary.
Okay, make sure. I don't know what happened here, but I can't get out of this. These are the only options it's given. Because my yeah, but my last job is. What happened?
Where on the corner, remember, Judge?
Back here? Well, because it minimized it and then okay.
Yeah.
You're still here?
I am, Judge. Have one more.
Is
it Middleton? Yes.
Give me any hints.
I'll give you one. Here's Middleton judge and then the public safety.
Aaron Middleton.
It's to your left, Judge.
It's not it.
It's not here.
Okay, what are we doing today here? 25 CR 906.
Judge, I have a request for a bond reduction. I have a copy of the motion if you need it.
Not got it.
I can have one too. It's just a basic bond reduction hearing and his bond is currently set at 250,000.
All right, 25 CR 906 is called You were Aaron Middleton. You were here with your attorney, Ms. McNally, and the state's attorney. You have been indicted as of July of last year for the second-degree felony of sexual assault, which carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand? So, in all bond proceedings, the court reviews the public safety report, which is a product of your criminal history that we know of. And this is all that's showing up. Have you ever been arrested before for anything before?
This is all he has, Judge.
Stand by. I'm going to look at the probably call real fast.
The lawyer is generous also.
With 2 years, is it food and I must have. But you get a little bite back on to suggest that it's better. You know, with a little bit more about that, this and this on. You're not appreciating. I don't know if it's ever been on this one, they've committed on the law and all that in probation. Yeah, but they've given it honestly, you know, it's all right. But honestly, if you look at facts on their belly, it's interesting. It's not interesting enough to talk about, but it's not. Ouch. So I do know you get a little about my back on the start GLT, which is just brings people.
Oh, I remember the day it's time. I said, I'll sit down. I want to do the fact that's out of happening. Okay. Yeah, that's.
You know what, man? Trying to make them it's I was up there probably for a reason on the county. Maybe I need to, that's what I think, that's gonna be my next step.
You might wish I'll turn it on and start back on thing.
Okay.
It's
Who's gonna be my next speaker?
Okay. For this, the probable cause affidavit here, anything from the state and then the defense.
Are we talking about regarding the bond, Judge?
Yeah, that's what we're going to.
Judge, this was just filed this morning. I have not even had the opportunity to look into anything. She just handed it to me. This is my first time seeing it.
Mhm.
Yes.
Go ahead, if you with the defense.
Judge, yes, that's correct. It was filed this morning. I
still don't care.
unfortunately just had the opportunity to do it this morning. I was at the jail a lot this past weekend, but in regards to the bond reduction, and as you can see in your public safety report, he does not have any other criminal history currently. He has ties to Beaumont. He has children here. His mother is very active on this case and is very active in speaking with me about this case and about him. He has not had any issues being in custody.
She wasn't a witness though to this event.
No one was except for the two people that were there, which is my client and Miss Williams herself.
Well, there's videos of him going in and out.
But nothing of the alleged altercation or whether it was consensual or not. It's basically a he said, she said. So with regards to his connections to the community and the level that the bond is currently set at, right now it's set sufficiently high to make sure that he stays in custody and is not sufficiently high to.
Was the defendant, defendant know the complainant before this event?
I don't believe so. Did you know? No.
Okay. So what happens? Yeah, I'm reading the probable cause. He delivers groceries to this location. Had not known this person. Was in for 14 minutes. And then admits during the interview with the police that he had sexual contact with the person. So he's never known her. He goes and delivers groceries, then leaves and admits to having sexual conduct. Generally, grocery delivery people, that's not part of the original method of handling grocery deliveries. So, I mean, this doesn't really make sense if she didn't know him before. And then she immediately calls the police. And within 20 minutes after the time period, and he admits to having sexual contact with her and that never seen each other before. And that's what happens during just a grocery delivery.
Judge, I have
it could happen, but
people's sexual encounters or their preferences or what that looks like. I mean, crazy things happen every day. But in terms of whether
I bet I've been around longer than you. I don't know how things can be, and this defies logic, especially when she made an immediate outcry, and this should put everybody on alert about grocery deliveries. That what can happen here is it can turn into a sexual event, which is not a good way of selling the product. All right, you're asking for what?
lesser bond that he can attempt to afford, Judge. It's set at 250 now. He has clearly not been able to make it since he's been in custody since July of last year. One that would ensure him showing up to court instead of one that ensures him staying in custody.
Judge, I would like Tom to be able to, I mean, I know defense counsel just testified to his ties to the community, but I would like to have Tom to be able to research his ties to the community as well as what he actually can afford.
This morning, Judge, she has.
All right. How much time do you think you need? Is a week good?
Yes, sir. That's fine.
We're gonna reset this for next week.
That's fine.
Okay? On Monday. See where things fall out on this. It's just probable cause affidavit is disturbing to read and this defies logic. Yeah, but didn't know the person, delivers groceries, has sex, and then she immediately calls the police. All right, we'll reset that. Thanks. John Dixon.
We just let him.
I'm sorry. Jasmine Holloway. Is that yours, John?
Yes, sir.
I'm gonna be a plea on 2 cases. You ready?
Yes, sir.
Where is she?
That's me.
What's the name, dude?
Jasmine Holloway, please.
Moderate.
So hard as I was, they thought that's gonna probably.
What are you doing on Ryan Leax?
Your Honor, I think I'm sitting down for a hearing. There's some discrepancy on me was in jail or not in jail.
Okay, we'll bring him out.
Yeah.
We'll deal with
Yeah.
where we go on. J-Trend Bob.
We can get about 4 weeks on that one. He just got brought in from mental facilities, competent on the water.
All right, reset 4 weeks on 24 CR 2475. Tristan Osmond.
Please, Your Honor, we got paperwork to turn in.
Yes. You were Jasmine Holloway? Have she signed in everything?
I do get her.
She needs your fingerprints real quick, please. Thanks. We did going on.
These are MCR, please.
Yes.
Oh, they're both in TRPs?
Yes.
Okay, then doesn't matter. I already have.
You don't need to.
I thought there was a.
No, it's fine.
24 CR 1168 and 21 3852 38572 are both called the state of Texas versus Jasmine Holloway. We have a first amended motion to revoke probation filed on December 3rd of 2025 in 38572. And then an original motion to revoke probation filed on that same day in 1168. Does the defendant waive formal readings of these motions? Can we proceed in summary?
You can, Your Honor, yes.
Please raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Okay.
Lower your hand. In 38572, this is a first amended motion to revoke probation alleges that on February 24th, 2022, in this court, you were sentenced to 2 years in the state jail, probated for 5 years for operating a motor vehicle while intoxicated. It was a state jail.
It was with a child
because there
passenger.
was a child passenger.
Yes, sir.
Under 15 years of age, actually 2 of age. Do you understand here what you are charged with?
Yes.
If your probation is revoked, you are looking at no less than 180 days up to 2 years in the state jail. Actually, what's the agreement in this case?
Judge, she's got 2 cases on the state jail. It's 18 months. On the other matter, it's 4 years to run concurrent.
18 on this.
Yes, sir.
18 in state jail and 4 months on this.
4 years.
4 years on.
3rd degree felon.
Yes, sir.
Is that your understanding of the plan in each of these 2 cases?
Yeah.
And if I follow these agreements, you will have no right of appeal of your cases. Do you understand? What is she, which one is she pleading to here in 38572? There's 9 violations. Anybody?
I believe you marked 1, 2, and 4, didn't you, Jane?
I didn't mark any of them yet.
You didn't?
Left that to you guys.
My preference is 1 and 2, Judge.
Allegation 1 states you committed the offense of obstruction or retaliation on or about April 23rd, 2024. I'm skipping that. That's not obstruction or retaliation. That's not specified enough, I think, in this one to move forward.
If I may, Judge, I apologize. That's actually the other cause number.
No, I'm talking about 321-38572 is what we're dealing with first. And the other one is 24 CR 1168. I'm doing them in a numerical and chronological sequence. Number,
So if I'm
what
back,
number
Judge.
two is number two?
Yes, sir.
Allegation 2 states you committed the offense of resisting arrest or search on or about April 23rd, 2024 in Jefferson County, Texas, in violation of your probation order. Is that true or untrue? Are you pleading true to that voluntarily and because it is true as it is alleged? Yes.
Yes.
You understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant the motion to revoke probation. Your probation can be revoked and you can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yeah.
Mind you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. And there, in the first amended, we've got public intoxication or resisting arrest.
If we could have a plea on count 8, Judge.
Say that again.
Count 8, please.
8, allegation 8 states you committed the offense of resisting arrest or search on or about November 13th, 2025 in Jefferson County, Texas, in violation of your probation order. Is that true as well?
Yes.
And are you pleading true to that voluntarily and because it is true as it is alleged? Yes. And is that yes?
Yes.
And do you understand a voluntary and knowingly made a plea of true to 2 and or 8 in this first amended motion to revoke probation? That is enough to grant the motion to revoke probation, and you can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true to that?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. An agreement's been reached. Your probation would be revoked. You would be sentenced to 18 months in the state jail to run concurrently with this next motion to revoke probation in 1168. Is that true?
Yeah.
If I follow that, you have no right of appeal of your case. Do you understand?
Yeah.
Yeah. He was eligible, but he's not in the family for years. He plays games in the community. Then shows up. Follow my number. Oh, really? Not in the process, but he's good.
Okay. I'm going to hold in abeyance for just a moment and go to 1168.
Count 2 in this motion, Judge, is the same as count 8 in the prior motion.
In summary, this, and we proceed in summary in this. In summary, on this case, it is alleged that on September 9th, 2024, in this court, you were sentenced to 10 years in prison, and that was suspended. You were sentenced to 10 years in prison for the 3rd-degree felony of obstruction or retaliation. Is all of that true and correct? And allegation 2.
Yes, sir.
States that you committed the offense of resisting arrest or search or transport on or about November 13th, 2025 in Jefferson County, Texas, in violation of your probation order, which is the same allegation number 8 in the previous motion that you pleaded true to. Is this one true as well as it is alleged?
Yes.
And are you pleading true to this voluntarily, knowingly, intelligently, and because it is true as it is alleged? And again, voluntarily and knowingly made plea of true to one or more violations of probation. That is enough to grant a motion to revoke probation. Your probation can be revoked. And you
One of them was, huh? That was very nice. It was very nice, yes. when I first saw the email and thinking, oh, because I just saw on my phone, I thought, thanks for the kind words from David. I'm thinking, I've got a copy, Judge. No, I just find it's just not labeled on benchmark for some reason. All right, we are here at the, this is Matthew Matuzaka?
Matsuzaki, yes.
Is that close enough?
Very good.
Very good. Okay, well, good. At Mr. Matuzaka's request to relieve him from a disability. There was a report of probation that was prepared. Has everyone seen a copy of that?
Yes, Your Honor.
Mr. Knippen, does the state have a position?
So, Your Honor, I was actually initially confused because I couldn't find that record of conviction that would have made him under a disability. And speaking with him just a few minutes before a hearing got started, it's my understanding that that's been expunged. And that occurred, did you tell me 9 years ago?
Yeah, it was about 9 years ago.
Other than that, it looks like he just has traffic offenses, no other criminal record. So given all that, the state would defer and take no position regarding the application, Your Honor.
Do you remember what you were convicted of? I know you said speed and reckless off.
I was convicted of felony fleeing and eluding. I ran from the police up 71. It was in Hamilton County.
Okay. And they expunged that?
Yes. I mean, I had to wait, I think 8 years after my my probation was over before I was able to.
To me, under current law, that's not an expungible offense.
Well, and it's interesting because you have it as a felony 4. Was there a felony 4? I guess if he was fleeing after committing a felony,
yeah,
it would be a felony 4. Because normally, at that time, fleeing and eluding was either a misdemeanor of the 1st degree or a felony of the 3rd degree.
I was really young, and they were really trying to make an impression on me. And I was 18 when this happened. Yeah, they were. I went to quite. I mean, I didn't have a license for 5 years. I was under probation for 5 years, and I had 5 years on the shelf during that probationary period. So yeah, there was a lot. I remember at the time there was a lot of teen incidents where teenagers were hill hopping, and there was a lot of accidents going on, and they were very much trying to eliminate that. I do remember that, and
okay.
This was all over the news for weeks.
Okay, I don't remember it.
Yeah, most people don't. I mean, it happened in Montgomery, but yeah, it was. I believe I'm almost 100% positive it was a felony 4.
Well, I went to Muller. Which hills are we talking about? Down Spooky Hollow? Down.
Well, I grew up right in Montgomery, right off of. But this was going up 71.
Okay.
It was just a terrible misjudgment on my behalf.
Okay. Anything else, Mr. Knippen?
No, Your Honor.
All right. This time the court is going to grant the defendant's request and relieve him of this disability. Mr. Matuzaka, I'm going to go ahead and prepare an entry reflecting that decision, and it'll be sent to you. Okay.
Thank you, Your Honor.
Thank you, sir.
Thank you for the court's time.
Yep.
To the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. It's also a term of your probation that you comply with whatever parole has for you to do. So as long as you're in line with them and you pay your restitution, do your theft class, and not have any contact with the victim, you'll be okay with us. All right, that's all.
In this case, a third-degree felony to no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yeah.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes.
Agreement's been reached here. In this case, your probation would be revoked. You would be sentenced to 4 years in prison to run concurrently with the 18-month state jail sentence in the previous case. Is that your understanding of the plan?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes.
Show you what's marked. As State's Exhibit 1, did you sign that document, understand it, discuss it with your attorney? Are the contents all true and correct?
Yeah.
State's Exhibit 1 tendered into evidence. Without objection, admitted in each of these cases. Among other things, they state that you are waiving any right of appeal if I follow these agreements, which I intend to do. State's Exhibit 1 made a part of the record in each of these cases. Without objection.
No objection.
No, just fine. Pre-sentence reports are waived here.
Yes, please.
I'm going to follow these agreements in each of these cases. I'm going to find Ms. Holloway in 21-38572 as well as 24-CO1168. You have pleaded true to the first amended motion to revoke probation in 38572 and the original motion to revoke probation in 1168 and pleading true to allegation 2 in 38572. And 8, allegation 8 in 38572. And to pleading true to allegation number 2 in 1168, number 2 in each case being committing the offense of resisting arrest or search on or about November 13th, 2025. That is allegation 2 in 1168 and 8 in 38572. And in 38572, the other allegation of a violation of probation that was admitted to was committing the offense of resisting arrest or search on or about April 23rd, 2024 in Jefferson County, Texas. Each of those pleas to one or more allegations of violations of probation, that is enough to grant these motions to revoke probation in each of these cases. By preponderance of the evidence or greater, I so find they should be granted, and thus your probations are revoked. In 38572, the state jail felony, I'm following this agreement. You are hereby sentenced to confinement in the state jail for 18 months. And in 1168, your probation is revoked in that third-degree felony of obstruction or retaliation. I'm following the agreement there. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 4 years. These two sentences shall run concurrently. Do you understand fully what has happened today, man?
Yeah.
Okay. Move forward and do better. That is all. Thank you.
No, everything's happening.
John. Who else?
Tristan Osmond as well.
And Tristan Osmond.
That's right.
Oh.
Well, that is poetic justice. The file fell in the trash can just then. Is that good luck or bad luck? Good question. You can't realize that. Yeah, Lacey, almost frozen. Now the thing's frozen. Yeah. I'm having trouble with the bag this morning. That's ridiculous. They're doing weird things. Something unrelated to it. There's no other problems myself along with these guys. Yeah. Okay. Just remember. They still promise to stay tablets, right? Oh, the new stuff doesn't work.
Yes. I mean, to redo the program.
No. We got one tablet over there. That one doesn't work. Depends. Do your finger on it, but then it's not.
We have one in the DA's office. It works.
Once
Old
we
tablet,
get
but
the
it
new
works for the good.
program on the new tablet.
Yeah, I was just yeah.
Oh boy.
Allegedly.
Okay, so
It's just, that happens to join matters once in 4 run.
okay. Who was it last? Yeah.
Holland.
We need
Yeah,
to talk
I am-
about too, you know, he's also.
Okay, you sent both of those to you?
Yes,
Repeat program.
they should be in my queue, but if not, they're.
Tristan Osmond?
I'll keep it safe on this one death and this is the other death.
21-38831 is now called the state of Texas versus Tristan Osmond. There is a first amended motion to revoke probation. You are Mr. Osmond. And you were here with Mr. West, your attorney and the state's attorney. Does the defendant waive a formal reading of this motion, first amended motion to revoke probation? Can we proceed in summary?
Yes, we can, Your Honor.
Raise your right hand, sir. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
In summary, this motion filed on May 25th of 2022. Where have you been for
TDC.
4 years?
TDC.
It took 3 years to get him out of TDC?
Was he caught at the property at Nacogdoches burglary of a cabin?
Oh, he's been in other jurisdictions?
Yes,
sir.
Yeah. Yeah.
Yes, sir.
So that's really been MIA. He's been in custody
Right.
this time since.
All right, in summary, this states that on January 31st, 2022, in this court, you were sentenced to 2 years in the state jail, and that was suspended. You were placed on regular probation for 5 years for the state jail felony of unauthorized use of a motor vehicle. Is all of that true?
Yes, Your Honor.
Sir. All right, which one of these? It's 6, 7, 8, 9 separate ones, although the last 3 are all called number 1.
Go on.
And what do you want to go on?
One,
Which one?
the first one, failure to unauthorized use of motor vehicles.
Allegation number one states that the first number one mentioned in the motion to revoke probation, and it is a first amended motion to revoke probation. You committed the offense of unauthorized use of a motor vehicle on or about March 13th, 2022 in Cherokee County, Texas, in violation of your probation order, which is don't commit another crime in this state or any other state or the United States. Is that allegation true and correct?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea true to one or more violations of probation, that is enough to grant a motion to revoke probation? And in your case, your probation can be revoked. You can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true today. When you touch everything, it erases it. If anything, it falls off the chart here, and you got to find it. It's just very also not friendly. Agreement's been reached. Your probation would be revoked. You would be sentenced to 18 months in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand? I'll show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection and admitted. This states, among other things, if I follow this agreement, you have no right of appeal. I'm going to do this. So you have no right of appeal. Do you understand?
Yes, sir.
Okay. Anything to add by anybody? I will follow this agreement and find you, Mr. Osmond, had pleaded true voluntarily, knowingly, intelligently to allegation number 1, committing the offense of unauthorized use of a motor vehicle on or about March 13th, 2022 in Cherokee County, Texas, which is in violation of condition 1 of your probation order, which is don't commit another offense. That is enough to grant this first amended motion to revoke probation by a preponderance of the evidence or greater, because I find that you have voluntarily and knowingly admitted to that violation. Thus, your probation is hereby revoked and you are hereby sentenced in accordance with this agreement to confinement in the state jail for a term of 18 months. Do you understand what's happened today, sir?
Yes, sir.
Anything else?
Nothing much, sir.
That is all.
Yeah, you get all the time. You know,
Awesome. You.
Thank you.
I just don't know this way. One more to plea on. I got a couple of issues.
Who is it?
I got Deontay Sustan to add on. I still got to just say more problems. Get one side.
Okay, hold on though, Tex.
Yeah, I got some other ones.
I've got Cameron Hernandez.
Your Honor, I think we're going to work with plea on that. That's Kyle's case, and we got some confusion.
How much time?
3 weeks, 4 weeks, whatever.
Can you do it in 2?
Yeah.
2 weeks. Cameron Hernandez, we set 2 weeks, ladies and gentlemen. Ryan Leax.
Your Honor, that one I think we're going to set for a hearing because there's some confusion over the dates as he was in jail.
All right.
What he understands, I know we understand. So set for a hearing, and that'll be the way.
Is 3 weeks good?
That's perfect.
All right, let's reset Leax for 3 weeks. I've got Stephen Allen.
Your Honor, that one is, I just got on my case last week. I've talked to Erica about that.
How's that going?
Fine. She's great to work with.
Yeah.
I have no issue.
Good.
But if we get, I'd say 2 weeks on, Your Honor.
You got 2 weeks on Allen. Thank you. Let's see, what are we missing? There was something else you were going to dispose of today, right?
Deontay Sustan. I don't know if it's on your printed off, but that's the one from the trial last week.
that we're going to try to resolve his other. I mean, is that ready to go? Not yet. I still need to get the paperwork. Okay, now. Get it. Let me know.
James Mendoza?
So you can be safe.
We'll need to swear and fingerprint in front of me.
So many, you'll need to bring it over to swear in, and then they take care of it. It's just right.
Well, Ellie already did. Yeah.
Mr. Mendoza, is that you?
Yes, sir.
You're going to need to go over to this lady. She will swear you in, and there's some documents that you need to swear on to. Thank you. And then come on over here. No, don't get closer to the door. Stay there.
Mr. Mendoza, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, you got?
Yes, ma'am.
Need for you to ink up your right one print.
Okay.
Raise it flat right there. You get up again. And right here. Stand in front of judges.
Yes, ma'am.
And we now call cause number 24CR1769, the state of Texas versus James Philip Mendoza. Correct? That's you?
Yes, sir.
And you were here with Ms. Perozzo, your attorney and the state's attorney. Does the defendant waive a formal reading, hello, of the indictment and the arraignment here? Can we proceed in some?
Yes, sir. He does.
Is he an habitual felon?
No.
What's the problem on it?
He is, Judge, but you just need, I mean,
it's got the 2 prior convictions out of 12 and 17
Yes, sir.
in chronological fashion.
Yes, sir.
So he is subject to habitual felony.
Correct.
But we're not going to go forward on that.
No, I need you to
It's going to just go on.
count 1 and 3 if you don't mind, Judge.
1 and 3. I sense a deferred probation.
No, sir.
I will not.
Why would it be one? What's necessary about it?
We have an agreement for a cap of 15 years, so
Oh, that's why it is.
I need you to elevate the 3rd degree to a 2nd degree, Judge.
Which I think I'm.
That is an interesting 5.
Think so.
I do.
It's just.
Looked at these things.
And to erase this, it takes 2 hands to move the eraser on this. Two fingers. I don't know where this was invented, but this stylus is a.
Somebody showed me the other day in county court too. There's a pen that you can buy, and of course it's your own, you keep it. And it works with these tablets, and it has its own eraser and everything.
Quite naturally, it would be up to us to buy something that would work individually.
No comment.
But I'm actually considering getting one of those because I've issued erasing too.
Jimmy Ham was agreeing with me with that no comment. It was no. He said no comment, but his facial expression was agreement. All right, I see where we are on this. All right, and if he waives formal readings of this, can we proceed in summary?
Yes.
In summary, Mr. Mendoza, paragraph 1, the initial indictment allegation states that on or about June 23rd, 2024 in Jefferson County, Texas, you committed the offense of evading arrest or detention with a motor vehicle, which would be a 3rd degree felony otherwise. Do you understand what you were charged with there?
Yes, Your Honor.
3, before that offense occurred, allegation in the 3rd paragraph alleges that in cause number 2012-433912. No, that's not true. Said
before you committed the offense alleged in paragraph 1 on June 23rd, 2024 of evading arrest or detention with a motor vehicle, you committed the felony of illegal possession of a controlled substance with intent to deliver, a first-degree felony, and were finally convicted of that felony on October 3rd, 2017, in cause number 2017-411396 in the 364th District Court of Lubbock County, Texas. Do you understand what you're charged with there?
Yes, Your Honor.
So if paragraph 1, you plead guilty to the evading arrest or detention, and paragraph 2, you admit true to, that enhances an otherwise third-degree felony of evading arrest or detention to a second-degree felony punishment because of a prior conviction. Do you understand the consequences here?
Yes. Yes, sir.
And that would mean that you would be looking at no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. I'm going to have to. Enhanced due to prior felony to second degree. Again, you're looking at no less than 2, and a fine up to $10,000 can be assessed. Do you understand?
Yes, Your Honor.
Aye.
Yes, Judge.
Is there any reason not to go forward with sentence today?
We're prepared.
All right, we have 11 days of jail time credit. Does that sound right to everybody?
Yes.
Yes, Your Honor.
All right, Mr. View, on behalf of the state.
Your Honor, from the state's position, count 1 carries with it a presumption for prison, and the burden of proof is on the defending factor sufficient that that sentence should not be imposed. I think the facts and circumstances, this defendant was already on supervision, 2 different states for similar that occurred within the prior year before this offense. Previous opportunities to engage in treatment through both of those programs. He was offered a reduction in Hamilton County from a third-degree felony and allowed to enter ILC. He did not engage in treatment clearly. I think that under those circumstances and the facts of this case, in which he was in control of a motor vehicle in public while under the influence, that a prison sentence, that the defense cannot overcome that presumption, and that a prison sentence should be imposed in the case if the court wants to consider him for supervision or release to a community-based corrections facility. Then I think he should file a motion for judicial release after the imposition of a prison sentence. I think the probation department is correct that Mr. Frey has not been taking his treatment seriously. I think even as characterized by his attorney to the court, that he kind of wants to do things his way, that he is not a good candidate for community control.
There's no mandatory fine on this, right?
There is no mandatory fine.
Okay. Officer Sukovecki, what's your take on all this?
Your Honor, it looks like he has been in treatment with DeCoach since October. After his last positive drug test, he moved into a sober living for additional housing support, which I think was a good idea. I have concerns, again, with the overall long-term compliance when it comes to substances, just based on how he answered some of the things in the PSI. We could transfer him to Hamilton County since they're already supervising him, but it doesn't seem like they have met with him monthly as we would here, with a little bit more accountability. If he continues to use it, I think CBCF would be a good route to continue on supervision.
Mr. Perry?
Thank you, Judge. Judge, I had a conversation with Rob just down at Community Corrections. He confirms what probation is saying, and that is, well, we all know he has accepted responsibility. He is on probation. to Campbell County. He is on probation in Hamilton County. He knows that recovery is his focus, given where he was several months ago during his arrest. Judge, I think he's taking the coach treatment very seriously. And just so you understand what my words were, I'm not telling the court that he likes every day of it. I think that he has his challenges. Those challenges, I think, relate to his use. I think he's happy that he's not using, but I think he also sees his recovery as more difficult than he could have anticipated. But at least he's reflective and he knows the course. The course is recovery, recovery, recovery. To that end, he is no longer living with his mother and father who are in this courtroom in support of him. They recognize that their home wasn't the right place for him. They also believe that the sober living that he's now at in Hamilton County requires more of him, more responsibility, more effort, more focus, and the focus really is his recovery. They're also optimistic that where he is now is the right place for his recovery. That being said, Judge, as far as what the court had proposed in chambers, Rob would like to ask the court to place him on probation here in Warren County. He would like to continue in the sober living at New Foundations in Cincinnati. He recognizes that the court will monitor him much closer here in Warren County than he would have been monitored in Hamilton County had this been transferred down there. But Rob also believes that he has a handle now on his recovery. As he puts it, every day is hard, but today was easier than yesterday. So with that being said, he believes that he can succeed on probation here at New Foundations with the coach and the IOP, and he'd ask the court to place him on probation here so he can do just that.
What do you want to tell me, Mr. Frey?
It's been a challenge. I realize that this was not my addiction has been more of a challenge than I thought it would have been.
I'm going to interrupt you just to ask one question, Mr. Frey, because it might impact all of the rest of what you have to say to me. Are you going to pass your drug test today?
Did I or can I?
Are you going to?
Yes.
Okay, go ahead.
No, it's been a lot more of a challenge than I thought it would be. I didn't have a clear understanding of this addiction as I do now. I mean, it's definitely been a challenge. I thought it would be easy. But I believe now that I have more support. I have a different kind of support. And I feel like it's something I can do, and I can step up to the challenge. I mean, I know that's the choice I take. I mean, I feel like I need that. I have to step up to the choice. So that's my choice, in my opinion. I'm not going to back down to it. I mean, it's my life, and I want to own it and I want to live it.
So here's where I'm at on all of this, Mr. Frey. What you are doing at this moment in time in terms of your recovery seems decent to me. And it seems like the path to success, if you can maintain it and if you're serious about it. So I'm willing to go along with the plan that you have. I'm not going to let the folks in Hamilton County supervise you. No offense to them. They're busy. We do a better job of this than they do in Hamilton County, probably than they do in Campbell County. So I'm going to supervise you and place you in 3 years of basic probation. I'm going to impose upon you the standard rules of probation, delegate to your officer the ability to make special or additional conditions as they see fit. You are going to be subject to random drug testing. I'm going to give you credit for the 11 days that you have already done. I'm not going to impose a fine. I am going to impose the cost upon you. It is going to be a special term of your probation that you continue in your treatment. and that you pass all of your drug tests and you quit driving.
I'm not driving.
Your license is suspended. You are not to be behind the wheel. So if you are driving, it's not a DUS. It's a violation of your community control, which means I could send you to prison or I could send you to a community-based corrections facility. And I don't know, Mr. Frey, when somebody finally turns the right sets of tumblers to open the lock on addiction, I don't know how that happens. If I did, I wouldn't be sitting here. I would be beside a pool somewhere, cashing my millions of dollars. So I don't know. Maybe you've got this figured out. Maybe you haven't. We're going to find that out pretty soon. We may find it out within the next hour or so, because if you don't pass your drug test today, Officer Sukovecki is going to do an in-custody probation. We're going to do a violation probably by the end of the week. You're going to be on your way to prison because you're not going to lie to my face in my courtroom. Then we'll talk about the treatment options when you get back. We'll call that the Mr. View plan. If you don't pass your drug test today, we're going with the Mr. View plan. If you do, we're going to go with the Mr. Perry plan, and we're going to see how that works. And I really do want you to succeed, Mr. Frey, and that's what our probation is about. We identify obstacles to your success, and we help you take those obstacles away. So if that's the way you want to look at it, that's great. If you want to look at probation, as somebody who is just trying to catch you doing something wrong, you're either going to stop doing things wrong or eventually we catch you. If you violate the terms of your supervision or you violate the state or you leave the state without permission, I can sentence you to up to the maximum penalty in the case, which is 36 months in prison, plus the optional period of post-release control of up to 2 years. I'm not going to impose a new license suspension. Your license is already under suspension. So if you can get that fixed or get driving privileges, I'm fine if you're driving, but you cannot be driving without the proper privileges. Anything else we need to do? Anything I forgot?
No, Your Honor.
No, Your Honor.
All right. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. You are not permitted to leave the building today, Mr. Frey, until I have a drug test from you. All right. That's all.
Thank you, Judge.
Thank you, sir.
Yeah.
Sit down.
The agreement that's been reached between the parties is you would be pleading guilty. Whatever sentence shall not exceed a cap of 15 years in prison. So we are looking at no less than 2 nor more than 15 years confinement in prison. You could be placed on deferred or unadjudicated probation. And if I sentence you to 10 years or less, your probation could be suspended and you could be placed on your sentence could be suspended and you could be placed on regular probation for up to 10 years. I think those are the different options that are available. We're going to have a pre-sentence report done, come back, and then everyone will add any additional information and then the court will make my determination based upon those options. Do you understand that to be the case?
Yes, sir. Thank you.
If I follow the agreement here, you have no right of appeal of your cases. Do you understand?
Yes, Your Honor.
I won't say cases, this case, but the plea in the 2 cases.
The other case is being dismissed, Your Honor.
At time of sentencing will be judged.
And 25-25, is it 1-1?
Should be 25 DCCR 1580, Judge.
It's one.
1580.
Ooh, this says 2540.
Let's get it. She's using a different counting mechanism. The actual cause number is 25 DCCR 1580.
So, yeah, I apologize. That was on the.
Yeah, you're gonna have to cause me to figure out how to erase.
It's one of my small goals of the day.
Is to put me through a lot of pain and agony. Here on.
We're all right there with you, Judge.
Yeah, I can feel your pain.
Maybe I'll get everybody a pen for the
All right.
birthday.
Your final answer on this dismissal of cause number. Help me out.
25 DCCR 1580.
1580 to be dismissed as part of this agreement. If I follow all of this, you have no right of appeal, sir. Do you understand?
Yes, Your Honor.
So how do you plead in this indictment to paragraph 1, guilty or not guilty to this 3rd-degree felony of evading arrest or detention?
Guilty.
If I follow this agreement, you have no right of appeal in this case. And paragraph 3, the prior conviction of delivery, 1st-degree felony of possession of a controlled substance with intent to deliver, a 1st-degree felony in 2017, paragraph 3, as that is alleged. Is that allegation true and correct?
Yes, Your Honor.
And are you pleading true and correct to that voluntarily and because it is true?
Yes.
And once again, I show you paragraph State's Exhibit 1. Did you sign that voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 tendered into evidence. Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crimes charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, Your Honor.
State's Exhibit 1 made a part of the record for all purposes. All right. I'm going to withhold further action and we will order a pre-sentence report, return back on April 13th of this year. And all parties will be able to add additional information and the court will make its determination at that time.
Thank you, Your Honor.
Yes, you're welcome.
What's awesome and but I think in the future also. Well, I think that's but still got thank you.
Brent, who do you have?
Cleveland, Baldwin, and Smith.
That's Christopher Smith?
Yes, sir. Mr. Smith and Ms. Baldwin should be pleased. Both of them, that's what they said. Baldwin and Smith should be pleased. And then Mr. Cleveland, Mr. Laird is covering for.
Okay, Chancellor Baldwin.
We're kind of negotiating Mr. Cleveland.
Okay, y'all still working on that.
I was going to ask for a 1 week reset since Ms. Gonzalez is not here.
All right, 1 week on Rodney Rochelle Cleveland Jr. Reset. Chancellor Baldwin, please. Who else was it? Is that it?
Sorry, Judge?
Is that all?
Yeah, that's two. Baldwin is Smith should be there.
Smith is going to do Christopher.
Yes, sir.
Okay.
I think Baldwin's
Chancellor Baldwin. James, you got something, James, on we'll take you right after Brett. Okay.
No worries, you need to.
It's
for the duration.
I'm sorry to hear that. I thought I was the only one
No, it's a,
for the duration. You're Chancellor Baldwin? Okay. And you were here with Mr. Turk, your attorney, and the state's attorney? You were charged with this motion to revoke probation here in cause number 20-34247. You understand? You have to speak out so she can hear you. Yeah, you're okay. Do your best because the court reporter has to speak everything, has to take down and record everything you say. So do your best to speak out, okay? Yeah, sore throat today or lost your voice?
She has some medical issues, James.
All right. Does the defendant waive a formal reading of this motion to revoke probation? Can we proceed in summary?
Yes, Judge.
And raise your right hand, ma'am. Do you solemnly swear or affirm any statement you make during this hearing on this motion to revoke probation and cause 20-34247 will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Thank you. This states that on August 21st, 2023, in this court, you were sentenced to 1 year in the state jail, and that was suspended, and you were placed on 2 years probation for the state jail felony of theft of property. Is all of that true? True. What are we doing? Which ones? Is it one?
One is sufficient, Judge.
Allegation 1 states that while on probation, you provided a urine sample on or about May 29th of 2025, which showed the presence of cocaine in your system. And that is in violation of condition 10 of your probation order, which is do not use or possess any drug. Is that true? True. Are you pleading true voluntarily and because it is true as it is alleged? True. Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, such as this one, that is enough to grant this motion to revoke probation? Your probation can be revoked and you can be sentenced to no less than 180 days up to 1 year in the state jail. True. Knowing that, do you insist on pleading true to dead? I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
For the court's education, Judge, she paid the restitution amount that was due, that is represented in number 3 of the motion to revoke probation, but that was paid on last week, Judge.
You want to say anything on that?
No, that he paid it.
Okay. We're only proceeding on allegation 1, so I'm going to attempt to erase 2 and 4. Good luck.
Voila.
Voila. The agreement here that's been reached by the parties is your probation would be revoked. You would be sentenced to 10 months in the state jail, given credit for all time you have served. Is that your understanding? True. If I follow that, you have no right of appeal. Do you understand? True. Going to show you what's marked on State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? Or the contents all true and correct? Yes. State's Exhibit 1 tendered into evidence without objection admitted. This states that you understand if I follow this agreement, I intend to do this. You have no right of appeal and you move on with your life. True. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is hereby waived here.
Yes, Judge.
I'm going to follow this agreement and find that you, Chance L. Baldwin, have pleaded true in this motion to revoke probation in cause number 20-34247. You have pleaded true to violation number 1, providing a urine sample showing the presence and possession of cocaine in violation of condition 10 of your probation order on or about May 29th, 2025. Thus, your probation is hereby revoked, as I find that to be true and correct by preponderance of the evidence or greater, and you were hereby sentenced in accordance with this agreement to confinement in the state jail for a term of 10 months. Do you understand what has happened today? Anything else, Dan? That is all.
You already good. There is along with it.
And
Smith.
Next, Smith.
Yeah.
Christopher Smith. Two cases?
Yes, Judge, he's pleading the MTRP, and I believe we're dismissing the possession.
Hello. Christopher Smith. I have Jason Smith. Where's Christopher?
Almost done.
There we go. Are you Christopher J. Smith? You have to speak out, sir, so the court reporter can hear. You were here with Mr. Turk, your attorney, and the state's attorney and the probation office.
It's the MTRP, he's pleading on possession to be dismissed.
If
That's my understanding of it anyway.
two cases, 24 CR 2350. There's a motion to revoke probation where you were placed on probation for state jail felony, though it was enhanced, I guess, for prior convictions. It was a state jail, and you were sentenced to 10 years in prison. Pleading true to allegations 2 and 3, 2 state jail felonies. So I guess that was state jail punished as though it were a 3rd degree felony. And then in 25 CR 1313,
Got the possession.
that was on actually what was interesting is God bless you. 24 CR 2340, the earlier numbered one.
It was the possession occurred before.
Was disposed of after. I'm sorry, disposed of after the other indictment.
That's correct, Your Honor. I think 1313 is going to be dismissed.
Yes. The new position.
Yes.
I'm lost. I don't see anything anywhere in here, but I'm lost. Okay.
I mean, that's,
I'm careful.
I know, well, I'm just.
I'm good. I'm good.
I know you're. But I want to make sure everybody's on the same page.
What started out?
Well, you know, it was one of my New Year's resolutions.
Okay, that's the 2340. That's all I have. 25 CR 1313. This new case filed September of last year on illegal possession of a controlled substance, methamphetamine, which is not alleged in this motion to revoke probation. But is that case going to be dismissed?
Yes.
Was that the plan? Okay, all right. So let's just deal with then the motion to revoke probation here in 2340. You were here with Mr. Turk, your attorney, and the state's attorney. Does the defendant waive a formal reading of this motion to revoke probation filed
Yes, Judge.
February 17th, 2026? And can we proceed in summary?
Yes, Judge.
Does the defendant waive any additional time periods he may have under law to prepare in this case?
Yes, Judge.
All right. And raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God. I'm sorry. Yeah.
Yes, sir.
Okay, lower your hand. In summary, this motion to revoke probation, sir, states that on August 4th, 2025, in this court, you were sentenced to 10 years in prison, and that was suspended for 10 years for the state jail felony of burglary of a building. Is that true and correct?
All right. Yes, sir.
All right. And it was sentenced, that was a state jail felony, which would otherwise carry with it up to 2 years in the state jail. But because of prior convictions in the indictment that you pleaded true to, 2 of them, then the punishment range was enhanced, even though it's a state jail felony, but it was punished as though it were a 3rd-degree felony, which carried with it up to 10 years in prison. Is all of that your understanding?
Yes, sir.
That's why you were sentenced to 10 years in prison, probated for 10 years, even though it was a state jail felony, correct? Yes. Yes, speak out so she can hear.
Yeah.
Do you understand?
Yeah. Ma'am.
Yes, I think you got to speak clearly.
Is all of that true and correct?
Yes.
Okay. All right. There is an agreement that's been reached here that you would be pleading true, your probation would be revoked. And stand down, see how this story ends. You'd be sentenced to 4 years in prison. And then this other case, 25 CR 1313, would be dismissed. Is that your understanding of the plan?
Yeah.
If I follow this agreement, you have no right of appeal of your case. Do you understand? So yes. Yeah.
Yeah.
So, allegation 1, again, alleges that you committed the offense of criminal trespass on or about August 17th, 2025 in Jefferson County, Texas, which violates your probation order, which is don't commit any crimes. Is that allegation true and correct as it is alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily and because it is true?
Okay.
Please, you can't hear.
Yeah, sure.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant the motion to revoke probation, your probation, and be revoked, and you can be sentenced to no less than 2, no more than 10 years confinement in prison? Knowing that, do you insist on pleading true today? Based upon this agreement?
Sure.
Yes. It's yes or no? Okay.
Trying to do probation. So.
Based upon this agreement, are you pleading true and correct voluntarily and because allegation 1 is true?
Sure. No.
I find you're pleading true and correct voluntarily. You understand and appreciate the consequences of pleading true. One other thing I just want to add here on Mr. Smith, this 1313 is going to be dismissed. That is an illegal possession of a controlled substance, a state jail felony. He's pleading true to criminal trespass. What about that? Is that going to be resurrected or is that not going to be followed? Y'all dismissing that?
I'll dismiss it, Judge. There's a note in the file that there was an
I don't think
offer made.
I don't even know what degree crime that is.
It's Class B misdemeanor the way it was
Class
alleged.
B, but it still could put him in jail for 6 months, but that's going to be dismissed,
Yes,
right? Or not going to be filed.
Correct, Judge.
Oh, you got that going for you as well. Do you understand the plan here? Anything else to add? You Judge? I'm going to find, if nothing further, Mr. Smith, that you have pleaded true to allegation number 1 of this motion to revoke probation, committing the offense of criminal trespass on or about August 17th, 2025 in Jefferson County, Texas. That is a violation of condition 1 of your probation order, which states do not commit an offense while on probation. And the court finds that true by a preponderance of the evidence or greater. Thus, this motion to revoke probation is hereby granted. Your probation of 10 years in prison, probated for 10 years of this state jail felony, enhanced to a third-degree felony for burglary of a building, is hereby revoked, and you are now hereby sentenced to confinement. And that's in the wrong place. You got confinement in the state jail. We can't confine him for 4 years in the state jail. I think you're going to be.
Well, that's the paperwork that was there.
Yes. You're going to be confined. You're going to be sentenced. Well, we got to try it. I can fix it. But it's going to take some, just a.
I'm on separate types of check over.
Okay, I think it's done. Your sentence is 4 years in prison to the state jail felony, punished though as a third-degree felony due to the original plea agreement and the plea hearing where you pleaded true to 2 prior state jail felonies, which kept this a state jail felony, but enhanced the punishment because of the prior state felony convictions as though it were a third-degree felony. That's why you're getting 4 years in prison, not a state jail, and we can't put you 4 years in the state jail. Anyway, that's not an available punishment under law. Do you understand what has happened today, sir? You'll be given credit for all time you have served in accordance with this case. I can't do parole. That's somebody else's business. But you will be given credit for time you have served.
4 years.
4 years. Okay. Well, all right. That is all. Thank you. And y'all are going to send me something to sign dismissal.
You judge.
25 CR 1313, a motion to dismiss Christopher Smith based upon his